Good morning, everyone, and welcome. Today is July 15th, 2015, and this is a regular meeting of the members of the New York State Liquor Authority. In attendance is Chairman Bradley, Commissioner Kim. Staff in attendance is Associate General Counsel Amaretto, CEO O'Brien, and myself, Secretary Held. The next meeting dates are set for Tuesday, July 21st, next week, and the first meeting set for August is the 11th, also on a Tuesday. All meetings are held in our New York City office with video conferencing available at our other office locations. Items will be called in the order as they're signed in, first in Buffalo, then Albany, then here in New York City. When your matter has been called, please approach the podium and state your name clearly for the record. As a matter of courtesy, we do ask that you silence your cell phones. Prior to the first item being called, Counsel's office has presented a proposed emergency summary order of suspension. It's been marked agenda number 2015-1655A for license serial number Onondaga RL 2505744, issued to the Continental Room Incorporated. They're doing business under the trade names Bar and Fuel, located at 400 South Clinton Street in the city of Syracuse. Presenting for Counsel's office is Deputy Counsel Ogden. Counsel?
Thank you. Good morning, Chairman Bradley and Commissioner Kim. Counsel's office requests that the license issued to the Continental Room doing business as Bar and Fuel, located at 400 South Clinton Street in Syracuse, be summarily suspended pursuant to Section 401, Subdivision 3 of the State Administrative Procedure Act. The record before you illustrates that the licensee is incapable of properly supervising the establishment and that it has no regard for the law. Recent serious incidents, as well as the adjudicated adverse history, warrant the issuance of an emergency order of suspension. On July 10th, 2015, at approximately 1:30 a.m. in the morning, officers of the Syracuse Police Department responded to the licensed establishment regarding an incident where a patron was stabbed. After interviewing several witnesses, including the doorman and individuals involved in the incident, officers learned that a physical fight began inside the establishment involving both male and female patrons. This fight then caused a larger fight, at which time employees began forcing people out of the bar. At that time, a large crowd gathered in the street, requiring the need for officers to assist with crowd control, and officers learned that a female patron sustained a large stab wound to her abdomen during the fight. A male patron was subsequently arrested for assault in the first degree, criminal possession of a weapon in the third degree, and menacing in the second degree. On May 8th, 2015, during the early morning hours, a female patron, after consuming alcoholic beverages at the establishment, drove her vehicle while intoxicated and killed another driver after hitting his vehicle head-on. During the investigation into this incident, the Onondaga County Sheriff's Office requested the surveillance video at the establishment prior to the accident. John Haynes, son of the licensee, runs the business and is identified to law enforcement as the manager. Mr. Haynes provided some of the surveillance video to the Sheriff's Office, but intentionally withheld several blocks of time. Upon discovering the missing portions, a search warrant was obtained and the remainder of the video was retrieved on a computer found within the establishment. A review of that video showed the female patron consuming alcohol in the establishment, and it showed her falling down several times in front of the bar. Furthermore, the security staff was observed to take no action at this time. In fact, they didn't call the police or an ambulance. Rather, the video shows the security personnel standing around watching her as she is being carried away by her hands and feet by two unidentified men. And sometime afterwards, she drove off in her vehicle and caused a fatal car crash. Mr. Haynes was subsequently charged with violating Penal Law Section 215.40, Subdivision 2, tampering with physical evidence. Lastly, the licensee is also being charged with using an unauthorized trade name. The name King is being used in connection with the business, however, Fuel is the approved name. As you can see in the documents attached to this request, the licensee has had numerous violations sustained in the past, including selling alcohol to minors, employing unlicensed security guards, selling and consuming alcohol during prohibited hours, suffering and permitting an altercation to occur, among other charges. The adverse history, coupled with the recent serious incidents, show that the licensee is incapable and unwilling to properly supervise the business. The fact that Mr. Haynes intentionally withheld physical evidence to law enforcement, potentially hindering their investigation, It is an egregious abuse of the privilege to hold a license. The serious assault over the past weekend, where a patron was stabbed, further supports the finding that the licensee is continuing a pattern of disturbances and disorder, and that steps are not being taken to ensure that this type of conduct comes to an end. These very serious incidents have already adversely affected the health, welfare, safety of the inhabitants of the area of the premises, and in consideration of them, immediate action in the form of an emergency order of summary suspension is required. Thank you.
Thank you. We have your submission. The evidence is very well laid out. This is one of the main reasons, clearly, why we are so vigilant about enforcing sale to intoxicated persons, sale during prohibited hours, and also having licensed security guards. It's because incidents like this, where they let somebody get carried out and then get into a car and basically kill somebody, and then following that pattern leading to stabbings such as this is the exact type of case where an emergency suspension is warranted. So I vote for the emergency suspension.
I vote for the emergency suspension as well.
Thank you.
Thank you.
Okay, we'll go to Buffalo. The first item is 1634, KJ and Family. Request for reconsideration, Carol. 1634. I know you wanted to weigh in on one of them.
Yes.
All right.
Correct.
This application had a deficiency letter sent out on it. We sent the deficiency letter on March 20th. The information was due for 3. We didn't deny it until 4/20. We have no information as to why the documentation wasn't submitted timely. His request for consideration doesn't say it. It would be my hope that this does not get reconsidered and they are made to refile.
Okay.
Because we put a lot of work into getting the backlog down.
Sure.
And this is what helps bring it back.
Okay. Are they here?
They're here, yes.
Sir, can you put your name on the record, please?
Yes, Peter Pecoraro, attorney.
Robert Heil, the consultant. Sick on nursing.
So you're here requesting a reconsideration of our denial. You've had multiple chances to comply with our deficiency letter, and we never heard back. And then on May 6th, you're asking for reconsideration 2 months or a month and a half after you received our deficiency letter. Do you have any explanation as to what's going on here?
I believe the item that was requested was a purchase contract, and this was never a purchase, it's a lease. And we have submitted the lease documents to the authority, and we don't have a purchase contract because we did not buy the business, we're just leasing it. I believe that's the only issue.
Well, the issue was that you were sent letters that it was delinquent, and you didn't respond to the letters until you decided you wanted to respond to them.
And there was bank financial information was required as well.
I don't know if they can hear you. Carry your mic's not on.
Do you have an explanation as to why you didn't respond to the letters indicating that your application was deficient?
The only explanation I have is that we did not buy the business. We were leasing it, and I had the lease submitted, and that would explain what was going on.
Sir, there was also financial documentation that was requested that hadn't been submitted with the application. So it wasn't just a contract of sale, which would be fine had we known that, had you responded to us, but the banking information wasn't supplied until the request for reconsideration came in as well.
I mean, you can't just ignore the letters. Whether they're asking for the wrong information or the right information, you never contacted anybody. So I'm going to deny the reconsideration. You can reapply and go that route.
I vote to deny as well.
Thank you.
Thank you.
Is there anyone else in Buffalo?
There's no one else in Buffalo.
Thanks, Michelle. In Albany, 1625 State Street Liquor and Wine.
Chairman Bradley, Commissioner Kim, good morning.
Good morning.
My name's Sean May. I'm here this morning with the applicant principals, Mr. Lin and Mrs. Lee. This is an application for to reconsider the decision to deny a liquor store, a package store application at the State Street location. I've submitted our position on paper. I just would like to point out that in 2014, a determination was made that this was in the public convenience and advantage to have a package store at this location. This location serves the Mohawk Commons Plaza, and it's approximately a mile and a half away from the closest package store, which is up by the other Crosstown Plaza on the other side of Route 7. I know that another issue was Mrs. Lee's history with her on-premises restaurant. Approximately, it was in 2007, 8-9 years ago. And if that remains to be an issue, we're certainly willing to remove Mrs. Lee from this application and limit her involvement in the business. I mean, she's going to remain as the landlord, but we certainly don't want that to get in the way of any approval or decision on this matter. As I said in my letter, this is the client's remaining asset and only source of income, and this has created quite a hardship.
What? It's all you because it's reconsideration. Yeah. Sorry, Mr. May, we're listening. It's
That's okay, Commissioner.
yeah. Well, I mean, no.
All right.
I mean, this is a request for reconsideration of a decision in April 7th, 2015, and Commissioner Green had voted no. I had voted yes.
Well, yeah, it's confusing how you did. She voted to approve the application. You voted to disapprove.
I voted to disapprove.
Disapprove, yeah, it's
Question was,
confusing how
should
it's
it be
listed there.
disapproved?
Oh, should it be disapproved? So I voted no, and she voted yes in April 17th, right? Got it. So it's really Chairman Bradley's decision here, because my vote's not going to change.
Well, even based on the information, Commissioner Kim, I mean, in 2014, a determination was made by the board that it is in the public convenience and advantage to have a package store at this location. And that was part of the denial decision. I was trying to refute and have you reconsider.
Well, I think I actually looked, and it actually Commissioner Kim pointed out during that hearing about the declining sales in the area. So I don't know that it was only the fact that one of the people on the license was a problem. And the previous store that was there didn't make it, and you pointed out that they just closed. But from what I found, they got evicted because they weren't paying the rent, and most people don't pay the rent because they can't afford it.
Well, it was an acquaintance relationship, and yeah, they just didn't pay their rent. It wasn't Mr. Lin actually worked in the store. The business was a viable business. It was a good business. They just didn't feel the need to pay rent. And we couldn't continue to operate like Mr. Lin couldn't continue to operate like that. That's not what, that's not a source of income from the
Yeah,
building.
I'm ready. All right, well, my vote, as I stated, it won't change, so I still vote to disapprove. I deny the request for reconsideration.
And I agree.
Okay. Thank you.
Thank you.
Okay, is there anyone else in Albany?
No, we're all set, thank you.
Okay, thanks, Rose. First item here is 1622, M&H Liquors.
Good morning, Commissioners.
Good morning.
My name is Malcolm Punter. I represent the Harlem Congregations for Community Improvement, and I'm here to oppose the application.
Okay. Is the applicant here as well? They're in opposition. Opposition. The applicant's not here? How many people are here for the opposition? Can you raise your hand, please?
Okay.
Okay.
Of note, we did receive a request on Monday to adjourn this item. Based on the volume of protesters, we told the representative that they need to appear and put their request in front of the board because we just had not enough time to notify everyone not to appear. So he was on notice to show up here.
I mean, I had to, huh?
You want to wait, or I don't want to ask all these people to come back so we can hear them if you want.
Right, okay, so why don't we do that? Just for sake of fairness, we'll have all of you in opposition put your statements on record, and then you don't have to come back for, you can, but you don't have to for when the applicant does show up at a future hearing.
Thank you. Mr. Chairman, Commissioner, as I said, I'm representing Harlem Congregations for Community Improvement, and we are opposed to the application for a liquor store placement at 2812-2814 Frederick Douglass Boulevard. This location is a gateway for the many of the lowest income Harlem residents remaining in the Harlem community. To allow a liquor store to operate there would be to relegate the community to goods and services that lead to chronic health problems and addiction of alcoholism. We believe that there are much needed essential services such as health care, education, tutoring, thrift shops. If the landlord of the Dunbar Apartments elects to rent to an establishment that will add to the ills of addiction and encourage hopelessness, we believe that this will have a negative impact on the community children who would be influenced by the image of an open retail liquor store, the second one in this community, and we oppose any liquor store in that area because it is a heavily residential area, and there are alternatives in commercial corridors nearby, such as 145th Street between Lenox Avenue and St. Nicholas Avenue. In addition to that, there are several institutions in the area, such as Harlem Congregations for Community Improvement, the St. Matthew's Baptist Church, the Thurgood Marshall Lower School, which houses kindergarten to 5th grades, both on West 151st Street, and the Dunbar themselves are home to hundreds of families, particularly area children.
Mr. Punter, are you just reading from the letter that you submitted to us? Because if you are, we have it on record, and we've both read it, so you don't need to repeat what's on here.
Sure.
It'll
So
go into the record officially anyway. So
Yes,
just to save you a
Commissioner.
few minutes.
And in closing, I just wanted to emphasize that Harlem Congregations for Community Improvement is working on a district plan for a commercial revitalization district plan, which really doesn't include bringing back, liquor stores that used to plague our community. There used to be liquor stores on every corner in Harlem, and we certainly don't want to see this in the Bradhurst district, because the Bradhurst district is still one of the lowest income neighborhoods in the Harlem community, and unemployment still is at a double-digit high in that area. And we also are applying to New York City Department of Transportation, HCCI, with partners to have what is called the Bradhurst Plaza right at the triangle in front of this store location. This triangle will be a plaza such as the plazas that are throughout Manhattan and the city, such as 42nd Street, 34th Street, which will allow an open air place for residents to safely to conversate and as well as other activities. Included in that plaza plan, which is before Community Board 10, is a farmer's market. So we don't want to promote health and then also promote alcohol and the potential abuse of alcohol. So that's my remarks, and thank you for your time.
Thank you very much.
Charles Lynn. I represent the closest liquor store to the applicant, 151st Street Discount Liquors, and with me is one of the principals, Naguib Galeb. I just wanted, public convenience and advantage will not be served by licensing this applicant. I did put as my exhibit letters from the following. I just point them out. I'm not going to cite them at all, other than the police department itself, which was the police service area number 6 in Manhattan, Assemblyman Herman D. Farrell, the Ralph J. Rangel, which is the Ralph J. Rangel Houses, 984 apartment complex, home to approximately 2,347 residents, and the Polo Ground Towers, 1,612 apartment complex, home of approximately 4,500 residents. the Bradhurst Merchants Association, as the Harlem Congregation for Community Improvement that we just heard from, and various opposition letters from residents and businesses in the area, and numerous petitions from the residents themselves. In addition, I think that what came in late was City Councilwoman Inez Dickens also wrote in behalf of the protest, as well as El Barrio Chamber of Commerce. These are all major associations in this area which specifically emphasize the enormous effort in this community to decrease crime, drugs, and alcohol. And that this neighborhood specifically is experiencing quality of life issues on a daily basis. In addition to that, as far as public convenience and advantage, there are 7 liquor stores in Harlem that are 2,500 feet or less distance to applicant, as per the LAMP site, the SLA LAMP site, and I put that as Exhibit 2. The 3 closest stores are within 1/10 of a mile, which is my client's store, and the other 2 are 3/10 of a mile away. This applicant also is on the same street or avenue as 2 of the other stores on Frederick Douglass Boulevard, which is also known as 8th Avenue, and this one would be right in the middle. So you have one going to the north and also one to the south. This would be in the middle. The one that's to the south, Frederick Liquor Inc., is a new licensee, having purchased its store in September 2013. That was a transfer. That was not a brand new applicant, but it is a brand new licensee in the area. And then Harlem Express Wine and Liquors at 108 West 145th Street, the 4th closest store, was a brand new license in March 2014, a little over a year ago. This area is being well serviced by the current liquor stores, and the strong opposition evidence that it is not in the public interest to license another liquor store in this area.
Okay, thank you.
Thanks.
So anybody else for the opposition? Would you just please get up and just put your name on, you don't, if you have anything new to add, please feel free to say it, but if it's repeating anything that you've heard thus far, you can just say ditto, I agree with what was said.
Sure. Good morning, Chairman.
Good morning.
Distinguished members of the
board. You can just call us board, yeah.
My name is Carlos Corella. I am the current owner of Rock Wine and Spirits at 2517 Adam Clayton Powell Boulevard. That's on the intersection of 146th and Adam Clayton. We've been there for about 5 years, going on 5 years. I'm not necessarily on board with some of the comments that have been made as far as liquor stores being the gateway to destruction in the community, but I do feel that it's tipping on the point of dangerous inundation. I think that there are several liquor stores, as mentioned before, that are servicing the community as is. Any more licenses within this saturated populace could cause a problem. I can say that we've been giving an honest go for 5 years, and for as many people may think that liquor stores are a gold mine, there really are a lot of work. And to have another competitor come in within just a couple of blocks could severely handicap our ability to stay viable. And that is my position, and I respectfully ask that you deny this application.
Okay, thank you.
Thank you.
Hi, good morning.
Good morning.
My name is Patriana Acosta-Pell. I am a business owner, I am a resident, and I also work with the Bradhurst Merchants Association, which is also a partner with Harlem Congregations for Community Improvement. We are a merchants organization in the area, and what we try to do is work with landlords to bring in certain types of businesses that are in the area, that are needed in the area. And for the past 5 years, we've been doing studies, as Mr. Punter has been speaking about previously, and liquor store is definitely not one of the things that is needed in the community. We need more things such as jewelry stores. We need a restaurant to eat. There's other things that we can hopefully consider in this process, and we'd just like you to deny this application.
Thank you. Come on up. She's a nice lady who helped me up the elevator with my crutches. Anyway, thank you. Thank you for that.
Good morning. My name is Bernadette McNear, and I represent Rango Houses.
Good morning. My name is Barbara J. Williams, and I represent Polo Ground Towers.
So we echo mostly everything that was said today. But, we're here on behalf of our residents of our communities, and the liquor store is just not what we need there. We have churches there. We have a big shelter there, men's shelter. There is social services for rehabs and everything in the area, and that is not an asset to them or to us. You know, they're here to help get their lives on track, and an added liquor store, it's just not viable for us up there on 155th Street where we are. And like I said, like the gentleman said, we have over 2,000 residents in our community, plus the Rucker Park. That's a huge event every year. So when that breaks out, and then you're going to walk down to the liquor store to keep the party going, it's just brings down the quality of life in our community.
Okay, thank you.
We're just asking you to say no to this. We do not want to reverse what we've struggled to raise the quality of life in our communities. And just echoing what has been said, we need more positive image coming to the community instead of a liquor store.
Thank you.
Thank you.
Thank you.
Good morning.
Good morning.
Just here, my name is Abdullah Al-Gaithi, and I don't think there was anything I could add to everything they said, and just agree with it. And
Thank you.
Are you a resident of the area?
I actually own a business, and I live 154 St. Nicholas Avenue.
Okay, thank you.
Okay, thank you.
Good morning. My name is Craig Williams. I am a resident of the area in Rangel. I'm also a temporary licensed alcohol and drug treatment counselor for Fortune Society. Fortune Society has been in the neighborhood. We service the community. I don't think this is a good idea. There's 2 halfway houses there that do not watch a lot of people that are released from the state prison. It's a gateway. If you advertise right in front of those halfway houses, listen, come on in. The halfway houses are run by Back on Track, which has not had a successful record, if you notice, in the New York Times. So as a drug and alcohol counselor that lives in the area, that works in the area, no, it's not a good idea. Thank you.
Thank you. Anybody else? Okay, we have the applicant. Oh, you, please.
In opposition.
Yes.
Good morning, Chairman Bradley. Good morning, Commissioner. And good morning, Commissioner. My name is Louis Malave. I'm the Executive Director of the El Barrio Chamber of Commerce. I'm here to give a face to the letter that I addressed to the Chairman. And I'm speaking about the economy of Harlem, East Harlem, and the economy there, as well as the economy in the entire state, is not well. And it is our belief as the Chamber of Commerce that another liquor store in the area will not serve the economy of the area. And we have enough liquor stores at the moment, and another liquor store will not be supported by this economy that we have now. And I want to congratulate the new board as being appointed, and I look forward to working with the board in the future.
Thank you.
Thank you very much.
Thank you. The applicant, please.
Good morning, Commissioner.
Good morning.
Morning. My name is Naoj Musfanat. I'm a president of the MNH Liquor Store, with location 2812-2814, Frederick Douglass Boulevard.
Can you just speak into the mic a little bit, please? A little closer, thank you.
2812-2814, Frederick Douglass Boulevard. Today I'm here to respond for opposition, but I'm not prepared to give them, I don't have any lawyer, I just found recently, and to need to extension for another week or a month to prepare to respond for them, because I got a lawyer less than 2 weeks, and the letter came.
Who's your lawyer?
My lawyers, new lawyers, Benston from Doland and Alex Company, LLC from Midtown.
When were you notified of all the opposition letters?
The opposition is
When did you know of the opposition?
The opposition is 2 weeks early.
2 weeks ago?
2 weeks ago,
And
yeah.
then you didn't? Did you try to get a lawyer, or you didn't try to get a lawyer?
We tried to get a lawyer because 2 weeks ago, and I got the attorney which is presented for hearing for today, and he is not full qualified to defend me. and I go a lawyer which is arranged to proceed to answer the opposition.
So here's the situation. As you can see, there is tremendous community opposition by residents, by businesses, and not licensees. I mean, there are licensee objections, but let's exclude them for the time being. But just the number of residents, the organizations, elected officials, from the city council person to the state assembly person, and then when you look at the nearest stores, you've got 5 stores within 0.5 miles. There's about 10 city blocks. And the largest one being 1,700 square feet. You're proposing 1,000 square feet space. The sales are increasing in 2 of the stores. In the other stores, it's kind of hard to tell. It's up and down and all, fluctuating very widely. So in terms of public convenience and advantage, are you prepared to address that issue without addressing the opposition?
I'm just to request to extension hearing period, because we just got from a lawyer just 2 days old, which is 13th. So I need to request for extension.
In terms of
just, you can, it's up to you.
Yeah, so, I mean, from my point of view, based on looking at all the information that's before us that was submitted, what we heard today, I don't know if there's going to be anything that you tell me that's going to change my vote, unless you tell me that something in your business concept is completely different from every other store that's nearest to you. These 5 stores are the nearest to you. So, and I don't know if you need a lawyer for that. So in some ways, I'm trying to actually save you the time and money of going to get a lawyer because there's nothing that the lawyer, I think, will tell me that's going to change my mind, unless it's a business concept thing that can provide public convenience and advantage.
And the lawyer can handle it in order to reply to the application.
Yeah, right, but all I'm telling you is that if you can tell me, is there anything about the business model? You can tell me about your business model, right? What do you plan to do with your store?
We have to go into upskills wines, which is open.
So only wines, no hard liquor?
Wine and liquor.
Okay.
We have to serve through the
so anything in particular? Have you been to these 5 nearest stores?
Well, we see, but they
Now, have you visited the 5 stores personally?
Yeah, they are far away from requirements. So I have to answer according to the question or the...
No, I'm asking you, sir, just have you been to the 5 nearest stores?
And the location, yes, they have...
Yeah, so you've been inside and you looked at what they sell?
They do, because...
No, have you looked at what they sell?
I have no inside the premises. I haven't been inside, but from...
Oh, you haven't been inside, so you don't know what they sell. So you don't know if what you're going to do... Are you going to do anything different, or are you planning to just go high-end, in general, high-end wine and high-end liquor?
We have high-end open upscales. Open space is...
Are these other stores open space, or are they bulletproof?
No bulletproof, just open for the public.
No, the other stores, are they bullet...
I think they have...
Do you have bulletproof? They're all bulletproof?
We don't do proof, just open up.
Okay.
Sir, here, what he's trying to tell you is that you've got a long way to go to convince us otherwise, and we kind of suggest that you deal with it today rather than go and pay a lawyer. If you want to go pay a lawyer, we'll certainly listen to the lawyer.
Please, and request for at least, I'm arranged with him, I discussed with him, I need 2 more time to review.
Jackie, when can we put that on?
I need at least...
Okay. Oh, August 11th. Then have them come back August 11th.
At least
and the opposition, you don't have to come back. You're all on record. If you want to come back, you're obviously welcome. But your comments have been taken into account. I took notes. Commissioner Kim took notes, so we're fully aware.
4 weeks, well, a month. That's why I arranged to review, answer. And
is that enough time for you?
Yeah,
August 11th? Okay, so we'll adjourn it.
4 weeks.
Okay,
so August 11th, good or no?
Well, how long is that? 4/11 is
a little less than a month.
So if you extend it for full 1 month, I'm happy with that.
Which is August 11th?
No.
If you want more than 30 days, so then it'll be the one after that.
They attach, they send me the sales details.
It's gonna be September.
Yeah, I don't think your lawyer's going to need that much time if you've already contacted them. More than, I think 4 weeks should be enough.
Because I got a letter from the Department of their oppositions, which is we have to go through. He got a paper, so you need more time to prepare to.
Sir, we gave you 4 weeks. This was on today.
Okay.
So you got 8/11. This is on.
8/11.
All right.
Thank you.
August 11th.
Okay.
Thanks.
1627 La Rolla Restaurant. Yeah, that's going to be a fun one. Good morning. Go ahead, state your name.
Good morning.
My name is Rolando Félix, president de La Rola Restaurant. I'm his nephew. I'm translating. He only speaks Spanish. My name is Asad Jawade.
Could you put your name on the record?
Sure. My name is Asad Jawade. I'm his nephew. I'm just translating for him.
I see. Did he put his name on the record?
Yes.
Okay, sorry, I missed up. Oh, well, so we're both. I'm ready to vote, and we grant.
Yeah, I approve the reconsideration.
I approve the reconsideration as well. Community Board came in and said that they have no objection to the alteration permit for the location.
So we're returning it to licensing?
Yes, so please return it to licensing.
So this is going to go back to licensing, and they'll review it. It's your reconsideration's been granted.
Appreciate it.
Yep.
Thank you.
Okay. 1655 Best Buy 888 Liquor and Wine.
Hello, my name is Javier Doral.
Hi, my name is Yun Zhao.
Okay.
Yes, we have opposition.
Yes, so maybe we'll first listen to the opposition, and then we'll listen to you. Thank you.
Good morning, I'm Glenn Wright. I represent the closest liquor store, the Ovan Valley Liquor Inc., which is only 555 feet away. There are representatives from two other stores here, the second and the third closest stores. I submitted a memorandum last week, addressing that this is a quiet street, it's a high crime area, they plan on being an open floor plan, the foot traffic in the area, and demographics and the increasing or decreasing sales of the stores. But before I get into all that, I just wanted to inquire whether or not the SLA has been made aware that there's an elementary school 130 feet away from this applicant on the same street.
I was not.
Yeah, I did a FOIA request of the application, and I see that they didn't mention it at all. But on the block plot diagram, they specifically say there's a preschool there. And so they were aware of it. But
Preschools do not count.
Preschools don't count.
I understand. Yeah, it's an elementary school.
Elementary school is different from preschool.
I'm sorry?
No, elementary school and preschool is different.
It's an elementary school that goes through grade 6. My point is that they're making they could be making a misrepresentation by referring to it in the block plot diagram as a preschool.
Oh, so you're saying it is an elementary school that goes through 6th grade.
Correct. And
what school is it?
I'd like to hand this up.
Sure.
I put together if you want to give that to them. I have a few copies. That's a website of the school. That's Google Maps, the distance, that it's 138 feet away. It's the certificate of occupancy saying that all 3 stories in the building are used as a preschool. I mean, the zoning says preschool, but nevertheless, the awning specifically says elementary school grades 1 through 6. I mean, if someone's preparing a block plot diagram, I put a picture there of the frontage and the awning, and that would have been what they were looking at. So for them to characterize this as a preschool, I think, is a misrepresentation. But regardless, I would ask that this be investigated.
It will be investigated.
I'll send an investigator out.
Okay. Should we go ahead and proceed with everything else?
Sure.
Put them on the record. Okay. So the applicant is opening on a very small side street that's off Parsons Boulevard. On that street, there's a small strip of stores. There's a huge municipal parking lot. There's a large church. There's some office buildings. Other than that, it's residential. There's a parking lot also on the block. There's not much foot traffic here. This precinct, I attached the statistics. It's the 103rd precinct, which has a significantly higher crime rate than the rest of Queens. I would submit that on a block like this at night, it would not be safe to have an open floor plan. I believe one of the other liquor store owners, he's the only one of the nearest four that has an open floor plan, will talk about the fact that he has a gun, that he has a security guard in his open floor plan liquor store. He's about 6 blocks away from this applicant. I would submit it's not safe, and I've attached those statistics. Now, my client only bought the store that he's in, Yovan Valley Liquor, last summer. So I wasn't able to attach, the income. He has no track record yet. But I would ask that he be given a chance to build up his business. He's having trouble getting a substantial clientele. I mean, the zip code where the store is going to be located has a 22.3%, of the population is below the poverty level. He is struggling. He's trying to figure out how to build up his business. He just filed an alterations application to try to reconfigure the area and survive. And I believe the other liquor store owners will echo that thought, that this area is already saturated. I attached Google Maps that it's a 3-minute walk from my client's store to this new store, directly around the corner.
Do you know if Liquor Mart Corp is operating?
He's here.
Yeah.
Where is he?
It said their data wasn't available.
Okay.
There are about 3,500 square feet of inventory within the nearest 4 stores. I believe they have a very good cross-section. I didn't see anything in the applicant's application that they're going to be offering anything different. They have on-street parking. I don't know if there's any specialty that they're going to propose, but I mean, I don't think they can make it. My client has no track record. I believe the second store has a slight increase, but the third and fourth closest stores, and the third closest store is here today to address that, they have declining sales, significant declining sales. So I would submit that this applicant is not offering anything different to this area, and it's just unrealistic to think they're going to do an open floor plan.
Thank you.
Next, sir. Liquor Mart Corp. So the reason why I asked if he knew if it was open, because we don't have 2014 and 2015 sales numbers from you, and normally if we don't get sales...
That's pending. Well, I put in the application,
Okay.
was pending.
But normally if we don't get it, then and you weren't here, we'd send out enforcement, just so you know.
Yeah.
Okay.
The sales for 2014 is pending because we do the corporation taxes yet. We asked for an extension.
Okay.
So tell us what you don't like about the applicant's store.
Well, it's a low budget area, and the stores, Liquor Mart is a freestanding store, and it's very security minded. Late hours, I have to have a security for the stores, and even carry a licensed gun.
Are you an open store?
Yes, freestanding. And wee hours like 9:30, 10 o'clock in the night. It's crazy. And opening a new stores will hinder us.
Thank you.
Hello, my name is Dennis Huang. I'm from Huang Sales Corporation, doing business as Hillcrest Wine and Liquors. Everything the lawyer said is pretty much what I wanted to say. So.
Okay. Thank you.
You said you had it on
Yes.
record, so
Thank you. Okay. It's your turn now.
Well, I wasn't aware of the opposition, and I see there's only businesses that are opposing. I guess I'll first mention the fact that they raised the elementary school I had it here down as a daycare. It wasn't a misrepresentation. I guess he says the CEO states that it's for a daycare as well. So if they're using it contrary to what it's supposed to be.
You're saying the CO says it's a daycare center?
Yeah, it does.
Right, that's what he
Okay,
stated.
I see. Okay,
Yeah,
thanks.
we'll be doing our investigation on that, so you can just move on to your presentation.
And then also, well, SLAM didn't list a school there as well. So there is a parking structure on that block. There's also a supermarket across the street. That's why, and a 70 family apartment building across the street. But mostly it is a commercial area. It is practically downtown Jamaica. The neighborhood has been growing.
Growing how much? Do you have population figures with you?
Yes, population figures that it has grown. For the Jamaica itself has grown 4% to 10%.
From when to when?
From the last census to the last census, right?
So it grew 4% or 10% from the last census?
Jamaica grew 4%. South Jamaica grew 10%, while Queens only grew 0.1%. New York City as a whole grew a little more than 2%. So it is a neighborhood that is growing. Her business plan is open floor like one of the liquor stores that are here.
And are you going to have security and also have a gun?
She was not planning on having a gun. She's not planning on staying very late. Her plan is mostly for wine. The other stores are the bulletproof type, which is very small, that sell only liquors. She's going for a different type of clientele.
What about Liquor Mart? They're open, and they're an open floor plan, and you sell wines as well. So
not so much.
Yeah,
Okay. She said that they don't have that much.
can you speak into the mic, please?
I already checked the stores. I found it's not big store. It's just a small, and then they supply not enough wine. I want to plan to more wines, and
What percentage will be wines for you?
I want to maybe like 60%. Yeah, because over there have a lot of Mexican people. They do a lot of parties, and then they can choose a lot of wines, and then they're gonna do.
Okay.
Yeah, and also over there have the supermarket. They go shopping, and maybe some come by to.
Where's the supermarket?
Yeah, just across street, just very close. And then I want to supply good service and bad quality, and nice to customers, and then give the convenience.
You didn't answer the security question. Do you intend on having security?
What's the security?
A guard.
A security guard
She was not planning on having
to prevent robberies,
Right.
The
crime.
windows.
No, like a security person, a guard, to stand in front of the door.
She was not planning on having none of the stores, nor the supermarket that is across the street has a security guard. They just have personnel that work there, and it's a large supermarket.
And what are your hours, proposed hours?
You mean the Monday to Saturday? Or like usually like 9:30 to 10:30. And maybe weekends maybe like 11.
Who else is going to work there besides you?
She has. She said she's going to have 3 other employees. She has a family member also that is going to be working with her.
And you currently work as a cashier at a liquor store in the Bronx?
Yeah.
Is the owner related to you in any way? Owner of the store where you work?
Yeah, I'm the owner of this company.
Are they?
Is she a cousin or?
Who helping me?
No, where you work now?
Oh, yeah, that's my relative.
Relative?
Yes.
What relation?
How close?
Just my family, a little bit far relationship. Just
Oh, it's a distant relationship?
Distant relative?
Yeah.
Do they have anything to do with this store?
Oh, are they doing a business partner with you?
Oh, no. I just work over there.
I see. In terms of the Yovan Valley, what percentage of your sales are, or what percentage of your inventory is wine versus liquors? Can you just give me the percentage, please?
My name is Kun Lee. I'm from Yovan Valley Liquor. The percentage of the wine, is that what you're asking,
Yes.
Commissioner? So we have maybe 35 to 40% of wine, and the other 60% are hard liquors like rum, tequila, and vodka.
And is there a particular type of wine that you stock mostly?
We offer New York wine, New York State wine, and then we
What kind of
offer-
New York State wines do you offer?
we do Taylor Port, Manischewitz, and we have a shelf only specific for New York State wine, like Brothers. That's just one shelf that's specific for New York State wine.
Okay, thank you.
And if it's okay, I just want to say a few words, if that's okay with me.
Sure.
I mean, with you guys. So we, as a family, we actually came over from San Francisco last year to New York to take over the liquor store as a business investment and also my job. It's a new liquor store. We've been having difficulties to manage the store because it's new. We're trying our best to get to know the customers. We have a list of the customers who wants to come in and ask for the wines that we don't have. We make a list and then I go get them, trying to satisfy our customer base and their needs. Personally, I just don't see a 3-minute walk store by walking distance. It's a walking neighborhood. Nobody drives a car, will really increase the convenience and also the advantage to the neighborhood.
Although, your store is only 600 square feet. And
Right. So that's why we mentioned, I already submitted the alternation. We're taking over the store next wall to me.
When was that submitted? When did you submit that?
I've actually attached that as exhibit to my memorandum,
Right.
but I did get a receipt.
Yeah, I remember seeing that.
It's been received. Yeah, my client's not, being successful. He's trying to reconfigure it, and the retail.
That's right. Now this brings up my point that I had taken a note on, was you're here arguing that there's no more space for alcohol and that everybody's being serviced properly in the community, yet you are filing for an alteration of a laundromat or something, right? Or space, or space next door to extend about 400 square feet? Am I right?
Almost double, it's 600 square
All right,
feet.
fine, 600 square feet. So then I kind of took it as, well, how can you stand here and argue for the saturation argument and then at the same time say the community can have another 600 of our space?
Sure. Because it's his livelihood, he came over from San Francisco with his family, his young child, his wife. They're trying to make a go of it, and they realize it's too small, and they realize that they have to double down. The space became vacant. The landlord likes him as a tenant. He's getting a very reasonable rent there. He's got to make the most of this investment. He's already, maybe it is throwing good money after bad at this point, but it's his livelihood.
I wanted to give a try because I realize my store.
No, I get that. It's just that you can't, if you're arguing that you don't need another liquor store here, and then you're saying that, well, but it can take on another 600 square feet, and I'm willing to put my money on it, the source, you lose credibility, right? I mean, that's just logical.
But foot traffic coming to a slight.
All right, no, okay, so anyway, I'm not going to belabor this. I'm just pointing that out, and no, you don't need to respond to this because we made our points. I understand your points. You're doing it as a livelihood, but anyway, if you're arguing that they can't have any more liquor stores and then you're expanding 600 square feet, to me,
He's trying to improve what he's got.
Yeah, and
I understand.
It's a plan. We not.
Yeah.
So.
I wanted to mention the supermarket.
Yeah, and also the supermarket across the street over me, there's also a supermarket. There's a fish market and also a supermarket by the bus terminal. So they come over to our store. Yeah.
Any other questions?
Yeah.
And I just want to address this school. I mean, the zoning does not drive whether or not this is legitimate.
We're going to investigate that, and if it's a school, it will be brought to our attention. You don't need to belabor that point.
Well, I don't want to belabor it, but I just don't understand how this applicant has not explained this awning that says elementary school, and yet they put it on the block plot diagram.
I don't believe he visited.
He didn't visit.
And the CO does say daycare center. That's what he's going on.
Okay.
But we're not going to go on that. We're going to send somebody out there.
Right, and if it's within 200 feet and it is a school, then by law, they're not eligible. So, you know, it's just, this is a walking neighborhood. There are 1, 2, 3, 4 stores within 0.6 miles. This one will be right around the corner from Tang's, and
That's actually a block over, but yeah.
okay, so it's a block over. It's around the corner, right?
It's 2 blocks around the corner, right?
My map has it as a block around the corner.
You cross 2 blocks and...
Anyway, it's around the corner, and you know, I just don't see how in this community where the majority of the stores closest here are still bulletproof, the other open floor plan has a security guard, and the owner has a gun in the store to protect themselves. To me, I don't see it yet in this community, so my vote is to deny.
There's just, in my view, enough liquor stores here. None of them are doing exceptionally well, and they're all either flat or down in sales. And it seems like while Mr. Yovan seems to be brand new, the other ones have been there a while, and their sales are consistently flat or down. I just don't see the public convenience to this as well, so I'm going to deny.
Thank you.
So I don't need Barry to
No. No, okay. 1615, Hamilton's Soda Fountain.
That's right. I remember that triggered it.
Yep.
What was it? 16?
1615.
All right.
Commissioner Bradley, Commissioner Kim, Chairman Bradley, Commissioner Kim, ladies and gentlemen. My name is Tom Monahan. I'm the attorney, and I represent Hamilton Soda Fountain, New York, LLC. Now, following a extensive negotiation with Ms. Flug and an assistant counsel by the name of Marsico, we hammered out a offer in compromise, which we're hopeful that this board would find acceptable as appropriate, given the nature of the transgressions charged. And I'm here to answer any questions that you might have relative to this submission of the offer in compromise of a...
But why wasn't the
6
ownership
month-
disclosed?
I'm sorry?
Why there was a non-disclosure of part ownership? Is that correct?
No, that's a mistake. The ownership of this it's an LLC where Chrysalis Coutinho is the sole member, but it was supported by 98% investment by her mother-in-law, and they misunderstood that. The mother-in-law is not a member of the LLC, and she did submit to, because I thought it prudent to have her fingerprinted as well, because of the fact that she is literally the financial wherewithal of the operation.
So the owner of the LLC is the sole member is who?
Her name is Chrysalis Coutinho Kinsella.
And who's Matthew Pastore?
Matthew Paratore is her husband,
Okay.
whose mother is.
Whose mother is the 90% investor in the LLC.
Yes, sir.
I have on our record that Marianne Paratore is she has 1% share, and she's an LLC member.
1% share, but she's a 98%
But I'm just saying she's listed as an LLC member on our
Right.
records.
a token membership. Correct, I'm
So
sorry.
it's not a sole member, there's two.
Correct, I stand corrected. 98.6.
And let me get this straight, so they had two restaurants next door to each other?
Yes,
And were
sir.
selling wine in one?
Young
And then
couple,
or letting people order in the other one as well? That didn't have a license?
what happened here is there was a sale of a glass of wine out of the licensed premises, which was brought next door, immediately next door to the
No,
second.
whoa. The sale wasn't out of the licensed premises, it was out of the unlicensed premises.
It was brought from that's the nature of the charge, the non bona fides. There's a licensed premises on the corner, 51 Bank Street. That's Hamilton Soda Fountain, New York.
Right.
Immediately next door is the second entity, which does not have a license, but it was in the process. It was 98% ready to be approved.
Yes.
They made a terrible
Well, hold on,
error.
is that accurate?
Is that accurate?
I was actually looking at the enforcement record.
Oh, Cafe
Is there an application for the other building?
Cafe Minerva.
Yes.
What's
Cafe
the address
Minerva.
on that?
Cafe Minerva, 304 West 4th.
And you're saying that was 98%?
Hold on.
No.
About to be approved?
Yeah, well, it was up to the point where the application was filed, a deficiency letter was served, all of the questions raised, respectfully, we addressed. And while that was happening, this incident occurred.
Well,
It's terrible.
And let me ask you,
Yeah.
is this an incident or was this a practice?
Oh, no, this is not, no, this was.
Well, where'd he get the menu?
Where's the menu from?
It was an old menu, but
West 4th
it was an old menu that was.
Listen,
locked.
I'm going to stop you here, because the one thing I can tell you is if you're going to tell me that the facts are different than I'm reading them, then we're going to end up at a hearing. If you're going to sit here and try to make a deal with us, I don't have an issue with that, but you have to be forthcoming, and you're not being
Well,
forthcoming.
please, sir, I'm not trying to.
Well, there was a menu, and the menu had wine on it.
But that was just, that series of events resulted in the withdrawal of the application for Minerva.
I understand that, but my point being, this was not an isolated incident. Your client had been doing this. Am I correct?
Well, I have no knowledge that my client was doing it, meaning.
So this is the first time in your knowledge that the menu came out and it happened to be to our investigator?
No, there was a menu that had these wines on the back of it, but there were no sales.
And the wines were to be ordered, correct? From the cafe that didn't have a license.
No, the cafe did have a license. The corner place had a license, Hamiltonian Soda.
I get that. The menu was in the other restaurant,
Right,
correct?
right.
And it had wine on it
That's the one from 2000.
Yes, sir.
that you could order.
Yes, sir.
Okay.
But there was no evidence that any sales occurred other than this particular.
I get that, but I'm going to make a jump.
Oh, well, could I just?
I don't even need to make a jump. The investigator sat down. He was given a Cafe Minerva menu. There was an extensive wine list. He picked one. The waiter left the restaurant and brought that wine to him. Now, that is a sale. He paid money.
Guilty. And
And you're saying that's the first and only time ever.
What I'm saying is, before the local board were these charges of this particular sale. And that's why the severity, if I may be subjective, a 6-month suspension is a very severe penalty.
To you, to me, it's not severe enough. When a licensee starts selling their alcohol for where they are only allowed by law to sell on their premise, and they start selling wine off premise, whether it was their mother, brother, sister, who owns the next door that also has a food business going on, that is a serious violation. And in cases that I've seen, that's cause for cancel and bond immediately because the person who's holding the license is not acting in the responsible manner that they're required to do. And this is very, very serious. When we have availing issues where somebody else comes in and acts as if they have the license when they don't, or when one location has a license but they're spreading out the alcohol to every other location on the block or one other location on the block that doesn't have a license, those are very, very serious charges.
Well,
so to me, 6 months is not enough.
Okay, well, but we're getting close to understanding it respectfully. My point is, I'd like to equate cancellation with capital punishment. And what I'm saying here is, in capital punishment, you deserve to have your license canceled. That's the punishment. What I'm saying here, the evidence that was submitted supported one isolated act. Now, as the chairman points out, there might have been others, but I'm not here to speculate. I'm here to hopefully resolve this.
I'm not speculating either, but my biggest problem, besides what Commissioner Kim just said, how serious, in my view, the violation is also the fact that it appears that your client has been licensed for a year?
Just under a year when
Yeah,
you
so I'm going to, I mean, if you want to make a counteroffer, I'll do it.
I have a counteroffer of cancel and bond. He's been licensed for a year. He understands that he needs to wait for his license for his other location, and you can't just start saying, oh, well, let's start selling next door because we're family. That doesn't work that way.
No, he's already, if I could, his pound of flesh was given when they made him withdraw that application, which he did.
He didn't withdraw it. We denied it for cause.
Denied and withdraw.
We denied
Again,
for cause.
We denied for cause because
Okay,
this was
but
pending?
isn't that a punishment?
Well, no,
that
because of the violation itself.
Right,
based on
this
the nature.
violation.
Yeah,
Oh.
not because it was pending.
But
Oh,
isn't
right.
that a punishment that he has to reapply? They're going under. They're losing everything, their life savings. I admit this was a monumental act of stupidity.
In this particular
it's not
case,
a
if
big-
we can't allow somebody to take their license and start selling alcohol in unlicensed premises, those are very serious charges. And if we set a precedent on this,
No, I'm telling you, they're guilty of that. What we're arguing about is a matter of degree.
No, we're not arguing about the matter of degree. We're actually arguing the fact that this generally, even the one instance that he got caught on, is reason to cancel and bond. And there's really no reason in my mind, given that he's had the license for under a year, why we should deviate from that.
But isn't that capital punishment?
Yes,
Without any evidence that there was a...
there is evidence. And if you want to go see the evidence, we'll have a hearing. But there's evidence, and that's the offer we're making.
Well, but there's only evidence of this one
And we're
isolated...
telling you that one isolated instance is enough.
the maximum penalty is revocation plus bond. We're not even going to revocation and bond. We're going to cancel and bond.
Yeah.
I'm just telling you.
Is there a difference between revocation and cancellation?
Absolutely.
One,
Yes, revocation he can't apply for 2 years. Cancellation he can reapply immediately.
but there is no future. If they take away his license, he's finished. The family, everything. Otherwise, law-abiding
Right.
people that
It's
made
her
it-
license, right? Not his license. You said his license. Well, that's one of the other
course.
allegations is that we came in on a complaint that he was really the true owner.
No, but wait.
And that was and that's not before us, but
But wait, but you...
anyway, our counteroffer is cancel and bond. You can go to a hearing if you
But he is
disagree.
Wait, if I might, I just
Sure.
want to correct this. It's been happening all the while. He is a principal of the other place,
Right.
the Minerva, where this was
Which
happening.
makes it even worse because he knows that he doesn't have a license and he's selling license on his on his premise.
And he
So he's
did,
doing double
and he
violations.
did, and there's evidence that occurred, and I'm
So
just
our
trying to...
counteroffer is cancel and bond. You can go to a hearing if you disagree or file an Article 78, right?
No, his opportunity is it'll go to counsel's office. He has a time to accept it. If he doesn't accept it,
Go to
counsel
hearing.
will schedule a hearing.
So
right
I'll
now, it's a
wait for you to
counteroffer.
get- Right. So you'll send me a counteroffer in the mail and make a decision.
Send the counteroffer.
Yeah.
If it's not accepted, counsel's office will set a hearing date.
And at the hearing, if there's no evidence of any other sale,
We're not. I've said this twice, and I'll say it one more time for you. I've said it twice. This is based on the one sale. One sale is enough. He went one time. That's all that's on here. took the wine from one licensed premise, brought it and sold it to a customer at an unlicensed premise. That's enough in our mind to cancel and bond. That's what's going to come out at the hearing. That's the evidence you're going to see. That's why we made this offer. And that's, you can take it or leave it. I'm sorry.
I mean, I just feel that there's...
And we understand, and you can act accordingly once you get our counteroffer. So thank you very much.
All right. All right, thank you.
Thank you.
1624, Keeley Wine and Liquor Corp. Kylie, Keeley.
Opposition's here too. Can the applicant just state their name and then we'll hear from the opposition first?
Benjamin Sharav, attorney. Mr. Chairman Bradley, Commissioner Kim. Benjamin Sharav, attorney for Ms. Josephine Teneo, the applicant for Keeley Wine and Liquor.
Okay. I just have one question before we hear the opposition. How many square feet is this proposed premise?
It's 650 square feet.
Okay, thank you. Just if we can hear from the opposition, please. Yeah, it wasn't on the...
It wasn't?
No. Usually it is, right?
No, I would usually double check it, put it on.
Yeah. Hi.
Thank you for the opportunity to speak. My name is Abi Stephen. This is my mom, Ancy Stephen, owner of Fordham West Wine and Liquor. We're here to oppose the new retail store for the following reason. One, since 2011, there's already been 2 new retail licenses opened close to our store, Carnival Liquor and Wine and Burnside Liquor and Wine, both walking distance, and this will be the 3rd one. Very close, will be the closest one to their store. According to the U.S. Census, there's only been a 3% increase in all of Bronx County, and if you look at your records, you've seen that there's many licenses approved in the Bronx already. It's very close to Kingsbridge Nursing and Medical Rehabilitation Center, which has treatment for drug and alcohol. It's very close to a park, which a lot of the teenagers hang out, and the St. Nicholas School and Church. I just don't see any reason for a small liquor store, which is very similar to ours, open very close to our store. We had to change our hours of operation in order to, to change, to get our sales up.
What are your hours?
Right now, we used to close at 9 o'clock. We're open to midnight now every day except for Sunday. We're open to 9 o'clock. We had to let go of some of our staff.
You're from Fordham West Liquor?
Yes.
And what percentage of wines versus liquor do you sell?
We have a whole section for wine and we have a whole section for liquor.
What percentage?
It's about 45 to 50%.
Okay, thank you.
Thank you.
In response to the objections, I just want to say that I think first he made a couple of perhaps misstatements. He talks about 2 stores opening close to him. One of them, Carnival, is close. The other one, the 189 Burnside Avenue, is it's about a mile away. That's 2 stops on the subway from this location. I think and as far as the proximity of his store to our location, they're not really all that close. I know that neighborhood very well. He's down Fordham Road on the other side, on the other side of Sedgwick Avenue, or west of Sedgwick Avenue, actually, in between Sedgwick and the Major Deegan Expressway. To get from there to this location, you'd have to cross Sedgwick Avenue, walk up Fordham Road, you'd have to cross Fordham Road and cross University Avenue. These are all major thoroughfares in the neighborhood. So they really are apart, almost really different areas that people wouldn't generally walk from one to the other. Store that we're proposing will be able to serve people both to the north towards Kingsbridge, which is quite a distance, and there's nothing in between there in Kingsbridge, and south along Webb Avenue, and really from every direction. And His is a very small store, and this is not as big as the store that my client wants to open, so I think if his store does have problems, it's not due to her store.
What happened to her other store?
Her other store, she sold it. She has a clean record.
Where was that?
It was 2 miles south, down 1442 University Avenue.
And that was just in this past February?
Yes.
And you've never had a violation?
No. She has a clean record. She's here to talk. She speaks Spanish, not much English, but she does.
Will she be running the store?
Yes.
Are you going to have a manager?
No, she's gonna manage the store, but she's gonna have.
By yourself? What are your hours going to be?
I spoke to her. She said she plans to open till 11 o'clock at night.
11 o'clock at night?
Yeah.
Did she run the other store by herself?
By herself with some employees. She has a good relationship with. She has good credit relationship with the wholesalers. She'll have employees to help her, but it's her business.
I'm just taking a look at the map.
Okay.
And that's this one. 42 minutes.
You said Carnival, the closest is, there's something separating?
I said between the
not
objector here is.
Not them. What about Carnival, the closest to you?
Carnival is the closest. That's on the other side of. It's on the other side of Fordham Road. It's west. It's towards. It gets also business from Jerome Avenue and the Grand Concourse.
On the other side.
Yeah.
So that means that the Fordham West Liquor is also on the same side as Carnival?
Yes, but Fordham West is really west. They call west for a reason. It's really far west. On the other side is Sedgwick Avenue, which is it really you leave the regular pedestrian commercial area. That's towards the Major Deegan and the University Avenue bridge to Manhattan from there. It's kind of not a pedestrian area. A lot of people really wouldn't walk past Sedgwick Avenue on Fordham Road.
All right, here we go.
That's, unless you
The
were
applicant. That's the applicant.
which is going to used to a car dealer.
Yeah, it's. I'm driving.
All right. Well, Chairman, are you ready to vote?
Yeah. Oh, yes.
Yes. Okay. Sure.
Just a couple of things. I mean, there's only a small park that's dividing their store to ours. It's right across the park. The second thing is, I did speak to the other. I did speak to the other liquor store owners in the area. None of them were notified of a hearing today. The only thing, the closest store, they did receive a letter, but explaining that there's a new store that are open, but nobody other than myself received a letter saying that there was a hearing today.
We only send letters to those who protest in writing. Otherwise, we don't know that they're protesting.
All right, and I understand, but they didn't know that there was a hearing today. They probably didn't know that there was.
Well, they must have known. They found out from you, though, right?
I did speak to them yesterday to find out if any of them were coming, and unfortunately, some of them weren't able to come because it was short of a notice. And also, there's another store right on Kingsbridge on the other side, which I think is closer to this store than what was on their record, which I think was somewhere on Burnside Avenue in that area, or 183rd Street. I think there's another closer store that they haven't listed on there, that they had no idea that this license was being.
They should have protested.
What's the name of that store? West Bronx?
Carnival.
What I'm saying is, there's two stores on Kingsbridge, right before Jerome.
There's a Clara Reyes and a West Bronx Wines and Liquors.
Yes, West Bronx Wine and Liquor.
Well, they're on here, so they need, they had an opportunity to protest.
It says it in the gross.
You know, the store is very close to our store. I'm not sure what he's saying, that it's on the other side of Cedric.
Well, I
It's
looked
very
at the
close.
map. I mean, it's not.
Right. I mean, you have it right.
It is 0.4 miles. So, I mean, there is a park
Again, you know,
too.
what
So
I'm trying to say is there's no added population. I mean, it's only a 3% increase. There's just been so many liquor stores. It seems like there's one every corner. And second, there's no added, residential units coming up. Or I don't see any reason why we would approve another liquor store. That's all I'm saying.
Yes,
Thank you so much.
Thank you.
Sure.
Yeah, again, it says liquor stores every corner. He's 0.4 of a mile away, which in a really
I can
dense
see that.
pedestrian
Yes.
neighborhood like this
Right.
is not right on top of it. And I won't reiterate what I
Right.
said about the
Okay.
walk.
All right, so I'm ready. Based on looking at the map, I think, and just looking at the applicant's clean record, and the size of the store, 650 square feet, I will vote to approve.
I also look at her record, which obviously, I think going back, when did you get your first license?
She got it in 06.
So 06, she has a clean record from 06. She just went out of business in February this year in the same borough. And the other stores in the area, while there are 3 within 0.4 miles, they all have increased sales over the last 3 years, some of them significantly. So I'm going to approve as well.
Thank you.
Thank you, Commissioner.
Good luck.
Is that it?
Yes, that's it.
Thank you.
1630 CVS Albany. Nope. Oh.
30, Albany CVS. Haha.
Hello. Good morning, Chairman Bradley, Commissioner Kim, and members of the board.
Good morning.
Andrea Hellman, an attorney for the licensee, and this is
Can you speak into the mic, please? Because it would just be harder to. You can move the mic around back and forth.
Okay.
Thank you.
Is that better?
Yes, please.
Okay. My name's Andrea Hellman. I'm an attorney for the licensee. This is Diana Hugimoff. She's here from my office. She's also an attorney for the licensee. We're here to respectfully request reconsideration in this matter.
Is there anything different from what I heard? When was this? When did we do this? June 9th? No. May 5th.
Yes. Have you received the written submission that we put in on June 9th?
Yes.
Yes.
Okay. And in addition to that, I'd also like to point out CVS does take compliance with the ABC laws very seriously. They have 458 licensed locations in New York State. They do have a very good overall track record. This year, there's been only one other location that's had a proceeding with SLA. Last year, there were about 2% of their locations that had a proceeding with SLA.
So what is it about this particular location that it's like an annual thing? And, we don't send investigators all the time, but it seems since 2011 June, we've had, and then even after you've gotten fined, subsequently you end up with another violation, and this is the 4th violation within 4 years of sales to minor. So there's something obviously seriously wrong with this location.
At this particular location, and we did investigate that, and what we found is that there have in fact been an enormous amount, an unusual amount of both manager and employee turnover at this particular location for some reason. So they have in fact had 4 managers within that 4-year period. There really has not been any consistency and a lot of employee turnover as well. And in this instance, the cashier involved was also a fairly new employee. What they have done now is they have a very capable manager that's in the position, and the district manager has assured us that he's going to make sure that this manager that's there now is not going to be transferred to another location. They're really going to be closely following this location to ensure that there's going to be a continuity of supervision there, so that it's someone who's really going to be on top, aware of the problem. In addition, what they'd like to do in this location is to install ID readers on all of the cash registers at this location. They already did have an effect, which has been effective at their other locations, a register prompt, where there's a series of questions. That's explained on page 2 of our submission, how exactly that works. And it's pretty involved, and it takes a lot for the cashier to defeat that, but it is possible either through mistake, human error, or intentionally for that to be defeated. So the ID readers would be an additional safeguard against that happening, because they wouldn't have the opportunity to say, okay, I think that.
Right, but CVS, as you pointed out, has 458 licenses in the state, and you're saying that only 1 or 2 or 1% or one other, you said, had a violation. And for me, the fact that CVS didn't take this location seriously until now, after the 4th violation, within 4 years, within a short period of time, that to me just, the turnover I get, that's an issue, but maybe until they figure that out, they really shouldn't be selling alcohol there. To me, the 4th strike is consistent with what we do for package stores and other licensees that have the privilege to sell alcohol. And while I commend them for proposing to put into place all these countermeasures now, I think it should have been done at least after the 3rd strike, a 3rd violation. And so my vote is to deny the request for reconsideration.
May I add one thing that it sets them in a little bit of a different circumstance from the other licensees. They do hold a lot of different licenses apart from with the SLA, and for purposes of conducting their business and other concerns that they have, they are affected differently by a cancellation as opposed to the proposed suspension, and that's a large reason why to them it would be important if there's any way that we could work out some sort of proposal.
What do you mean by that? You mean that if they get canceled here?
It could affect other licenses throughout the state. It could affect, not just alcohol. There's many different licenses that they hold. They have pharmacy licenses. They have different licenses. I don't know all of the specifics, but there are other questionnaires, similarly to when you fill out a liquor application and you're asked questions, have you ever had a license canceled? This could have other reaching effects for them beyond just the cancellation at this particular location. And, that was a large reason why we were proposing if it would be possible to do it as a suspension for a proposed period of time combined with a civil penalty.
I'm sympathetic. I understand that this might cause other issues for the company. And, 450 licenses, and they don't have somebody understanding the seriousness of sales to minors. I mean, you were probably here earlier where we had sales to intoxicated people, and then other places where sales to minors has led to serious issues otherwise related to alcohol. And, to me, that's something that they should have been focused on earlier, and hopefully that something like this will make them realize how important it is for the other 457 stores now that will have licenses to put into place whatever is necessary to prevent future cancellations.
Okay. I mean, I do want you to understand that they do take it very seriously, and they did, after the 3rd offense, take measures. They felt, that were going to be effective. Everyone was retrained. They do biannual internal training that's very extensive. They it covers with all of their employees how to refuse a sale, what forms of ID are appropriate, how to spot phony ID, how to spot a customer that doesn't look like they're properly attached to that ID, and then they have the register prompts, they have the training.
And I think we took all that into consideration in our original decision. I mean, to me, 4 times within 48 months, 46 months.
Even if we couched it as a 1-year suspension as opposed to a cancellation with some form of civil penalty, I mean, it would still be taking the license away for a very lengthy period of time. That
I don't know, what do you
would be
think,
a very
Chairman?
strong showing to the
2-year suspension?
I'm staying out of this since we're here.
Um,
I'm going to override what was already done.
Right, so, you know,
I mean, my understanding is that after a cancellation, generally the time period in which it would be appropriate to reapply would be approximately a year. So, in essence, it would be that whole period for a year, they would not be able to sell at this location, which, would be a very severe penalty. It would be for the entire year. It would just be couched as a suspension. We could do a civil penalty with that.
does that go? Suspension?
It's up to you. I believe it's just renewed.
Their renewal is pending pursuant to SAPA and
Yeah, they're under
SAFA, and they actually did stop selling until this is resolved voluntarily. And they also went to ID all in the store at this point. Like, everyone has to be ID'd no matter what.
Yeah. And so now you're saying they are going to put in a scanner here?
Yeah, they'll put in a scanner at this location.
And what are they going to do about the turnover issue, which seems to be the underlying issue you're telling me?
The DM that they have now is very experienced. I've been working with him for a very long time, and this is his district now. And he has assured me that the manager that is in place now is very capable and completely aware of what's going on, and is really going to be on top of this, and they're not going to take him out of the store.
All right. Well, we're just here to also just reconsider, right? So if we grant the reconsideration, then do we impose the penalty now? We can't.
Still a counteroffer?
It would still be a
They'd have to, well, it is a counteroffer, but they would, if you make an agreement, then I'm sure they would.
You're authorized to accept that now?
I'm sorry.
You're authorized to accept a counteroffer now if we give you one?
Up to certain parameters. I mean, I had basically come in with a counteroffer of a 6-month suspension, $5,000 civil penalty, and installation of ID readers at every register within that store.
Can you go beyond that?
I'm definitely open to.
So 1 year, 10,000, with all the steps you're talking about, and really the absolute last straw on this location?
Okay, so it'll be 1 year suspension, $10,000 civil penalty, and installation of the ID readers on all registers at this location.
Yes. And you said the retraining was already done?
Retraining was done for everyone in the store, and they do the retraining biannually, so the next retraining again for everyone would be in September.
So will they be getting the ATEP certificates?
They have asked me to look into that for them as well.
Yes, I would require that of the manager, whoever the manager is at the time. So if the manager changes, the new manager should have ATEP training for this location.
So when the suspension comes off.
Correct.
Okay. And would it also be when the suspension, just before the suspension is coming off, that's when they would anticipate to put the ID readers in?
Yeah, that's fine, because you don't have a need
As
for
long
it.
as they're there the first day you're selling again.
That's right.
Okay. That's acceptable.
Okay. I agree. Thank you.
Thank you. So
Okay.
will we receive that as a counter offer then?
Well,
Yes.
if you verbally accept it, then we'll send out the penalty letter, and then the suspension would probably commence within 30 days.
Okay, thank
Okay.
you.
All right, so are you verbally accepting or not?
I am, yes.
Okay, thank you.
Thank you. Thank you very much.
Thank you.
I'm sorry, 1568, Barrel Wine. 1568.
I do know how to pronounce that correctly.
Barrel
I would
wine?
have done barrel wine.
Barrel wine.
Is it barrel wine or barrel wine?
Baja wine.
Oh, Baja wine?
Yes.
Baja wine? Okay.
Barrel wine.
Oh, interesting.
Well,
I was complimenting you.
It's not that I don't go there. Okay, just saying.
Okay, so the method of operation, you haven't been complying. It seems like noise is a big issue. Yes?
We had a problem with one neighbor, yes.
One neighbor?
Only one neighbor.
I'm
My
sorry,
direct neighbor.
Did you put your name on the record, please?
Oh.
Fabrice Warren. I'm the owner of Baja Wine.
What do we do with this in this case? Evidence, no interest.
So my question is that your application indicated no dancing and no DJs, and now there's DJs?
Yes, live music, correct. But when I did the application, I didn't plan on having live music. And somehow the customers start to ask for, and we've been playing.
I get that, but your customers could ask for a lot of things. It doesn't mean
Sure.
you can do it.
Yes, sir.
I think we need an executive session for
Okay.
this.
We're going to have to go out for a couple minutes. We're going to take an executive session.
Sure.
Executive session.
So it looks as if, there are multiple neighbors complaining, and it really is coming from the DJ, the music. And you said your customers want it, but that's not in your method of operation, right? You're supposed to be a restaurant. You're not supposed to be a DJ.
We are a restaurant. The DJ we had a problem with get fired pretty quickly. It's a restaurant. It's a family restaurant. It's not a nightclub or a late night bar. It's just.
What time do you close?
On the weekend, midnight. On the weekdays, 11 p.m.
So what's the DJ for then if it's not a club?
It's just we playing music from the 70s, from the 80s, like Marvin Gaye. That's kind of ambiance we brought in this restaurant on that location on 120th Street.
The investigator Vega was there up until 1 a.m. So they stated to.
The kitchen closed at midnight, and the bar can stay open a little bit longer. Yes.
Till when?
But usually the DJ stop at midnight.
But till when does the bar stay open?
Until the last customer leave.
Well,
but we're not a late
you said
place.
you weren't late night, and 1 o'clock maybe isn't late night, but 4 o'clock is.
No, we're not
So
4
the
o'clock.
bar go to 4 or no?
No, never. One will be the latest. 1:30.
So why do you advertise that you have champagne parties with dancing every Thursday night starting at 7?
That was a mistake. We did a night, it was called Wine and Heels, where people come very elegant, and we have a very festive ambiance with the music and the champagne. But somehow the designer of that advertising puts dancing on the flyer. I missed it. I regret today to not seeing it.
So you don't have dancing.
We don't have a dancing floor. If you see the blueprint of the restaurant, this is very narrow. It's not a place where we can dance. It's table on the back. The bar is very narrow. There is no dancing floor.
But some people do dance on occasions.
I'm sorry?
Some people are dancing on occasions there.
In my restaurant? I can't disagree. Some people just do these kind of things, yes. But it's not like a nightclub where people dancing, absolutely not.
I know, but dancing's dancing.
There wasn't a DJ approved anyway in the original application.
I mean, I think this whole proceeding indicates that you're going to have to do something about the noise. You either got to get rid of the DJ, and you shouldn't have it anyway because your application doesn't indicate you have one.
The DJ is gone. We have no violation from the police who came.
But you're getting a lot of calls from the police. The police are getting a lot of calls about you.
I proved to the judge the call was from only one neighborhood. It was him and his wife. It was only two people calling on a regular basis every 7 days of the week around the same time.
Is the restaurant soundproofed at all?
Yes. I use green glue between the shin rocks.
What about the ceiling?
The ceiling?
Yeah.
It's soundproof?
The ceiling is soundproof, correct.
All right, and what about these calls are from 2013? Are the police still getting calls about you?
No, sir. And the police never made any violation. We have as well the DEP who came on the purposes.
Well, I get that, but it doesn't have to be a police violation to end up here. That's the problem.
Well, 2014, they were getting calls, June 2014. And so the DJ's gone forever.
Yes.
No dancing, and you said, oh, well, people just get up and do that. I think you still have to go and stop them from doing that.
Absolutely.
Or get a cabaret license.
Correct.
And you're saying it's soundproof, but the noise just seems to be...
It was this particular DJ who used a piece of equipment I was not agree on. It's called a sound-based system, who make vibration. And when my neighbor complained, I asked the DJ to stop right away, and it took me a few weeks to fix it.
Well, I don't think you stopped right away, right? Or the DJ didn't stop right away because it started...
He didn't listen to me. I had multiple meetings, and I just had enough, and I fired him.
Okay. It went on for 6 months, but okay, fine. So as to charge 3, dismissed, charges 1 and 2 are sustained. I have a penalty of $5,000.
I'll agree with that, 5,000. And for your information, charge 3 is dismissed because no evidence was presented to the ALJ. So it's 5,000 penalty for charge 1 and 2.
Okay. I think it's non-negotiable, right?
Excuse me?
I think it's something non-negotiable. This is what it is, right?
Yeah.
Okay, I got it. Thank you.
1650.
Yep, that's it. He'll get a letter, right?
Yeah, we'll send you a letter and, okay. 1654, Salon Corona Bar. Are you? Opposition? Well, come on up.
No applicant?
No applicant. Yeah, Ms. Rosenbaum.
Thank you. Edmund Rosenbaum, Community Board 3 Queens. Came in opposition. I don't want to read the letter. You received the recommendation from the Community Board?
Yes, we have it.
Okay. Additionally, one of the main issues is, besides the fact that Roosevelt Avenue, it's maybe 50 feet away from Roosevelt Avenue, which is one of the largest saturated areas in Queens itself. Even though this is tavern wine and not subject to the 200-foot rule as far as I know, there was a church within, I measured it myself, about 178 feet. Very large Greek Orthodox church. Even before that, the priest's residence is about 2 houses before that, so that's like 130 feet away. Also,
did we do a 200-foot?
It doesn't have to. It's a
doesn't
beer
have,
wine.
no.
Oh, beer wine. Okay, got it.
Yeah, he had originally started out with full liquor, his application, and came to us like 3 or 4 times. We kept denying it. And then went to tavern wine. And I can't remember how many years it's been, but at some point the local precinct had went in there on illegal parties. It's in a basement location. And you could actually fit 120 or so people. They have a public assembly, but he's only asking for 56, I believe, 52 people. And I don't have a picture. I don't know if you have a picture. Outside of the building on 98th Street, there's a illuminated sign advertising party hall for rent, Salon Corona Bar, and then a scrolling sign. So that's our opposition.
Okay, thank you.
Thank you.
Thank you. So this is a tavern wine license. It's not a 500-foot rule. Okay, so is there anything about
No experience.
the applicant doesn't have any experience. He's been in construction since 2000. We have a community board objecting, noting the presence of a Greek Orthodox church less than 150 feet away.
March 15th, they were issued a summons for running a nightclub.
March 15th of this year? How'd that work out? No, I mean, has that been, is it?
I don't have a disposition of it,
Okay.
but I know there was summons.
Okay.
Assuming with alcohol being served or just running the nightclub? Also issued violations for running an unlicensed nightclub. So I think based on those facts, there's good cause to deny this application.
I agree.
All right, disapproved.
What else do we got?
1633 Lexington Selections. Request to reconsider.
Let's see.
I'm okay with it. Yeah.
All right. I'm okay granting this reconsideration, Chairman.
Could we put your name on the record?
Okay. Good morning, everyone. I'm Scott Ross from Lexington Selections.
I'm okay granting the reconsideration as well. So does that go back to licensing now?
To licensing
Okay.
for full review.
Okay, thank you.
Was it something I said?
Yeah.
Or didn't say.
You can go back to your client and tell him you said a lot.
So, you receive a letter from licensing. You're
Yeah.
going back into a pending status. They're going to review the application.
If there's any deficiencies, we'll send you a letter telling you what they are, and you'll correct them.
Okay. Approximately, what's the timing on that? A few days? Or?
Oh, you're the
I'll
owner.
have it reactivated when I get back to Albany tomorrow and have the examiner review it immediately.
Okay. Thank you very much, everyone.
Yes, good luck.
1623 1910 Waterfront.
Why ignore community board 4?
1633?
23.
Ladies and gentlemen, my name is Christine Berthet. I'm the chair of Community Board 4 in Manhattan, on the west side of Manhattan. You have received 3 letters from our office to deny this application, this transfer, in fact. And the reasons we would like you to deny are that, first, this is a transfer from an operation which was operating until midnight or 1 o'clock, and they are asking now for 4 o'clock in the morning. This is in the middle of an extremely residential neighborhood on which we have, on other blocks, have had issues with noise, and they are asking for recorded music. And the third reason is that we have asked 3 times the applicant to show up in front of the community board, and they have not responded, or in the last instances, because we wanted to get on a good foot with the applicant, I called personally the lawyer. The lawyer said, absolutely, we're going to do everything possible. Then they responded to me. I proposed some date. I suggested that we meet offline. And at that point, they stopped responding to my emails. So I'm concerned that this applicant, first, is going to cause trouble, because 4 o'clock is not a good thing in that neighborhood. And second, our community board is very active in trying to mitigate problem with the community, but if the applicant is not ready to engage in the community, I figure that it's going to be a problem no matter what, and we won't be able to resolve issues. Therefore, I'm asking you to deny this application.
Did we hear from this guy?
No, this is Joe Levy's case, and he's always here for his cases, especially when so I did just email him to see if he is on his way, because he normally doesn't show up until about noontime.
Okay. Ma'am, there was a restaurant there previously, correct?
Yes, Moran's has been there forever. And that restaurant's open, was from typically 11 o'clock, midnight, didn't have music.
It was only open till 11 o'clock or midnight
Yeah.
with no music?
Right.
So you had no problems with it?
No, we had no problem. I mean, we wouldn't have any problem with this one. I mean, and we just want to make sure that it was not going to be open until 4 o'clock because they have, and so that's these are the two issues. We have problem not far away, right and left. It's very, very residential.
Okay, thank you. We're going to have to wait for the applicant to come. You're welcome to stay or...
I've waited for 4 months.
I have no other items signed in. Do you want to just proceed with the remaining items on the calendar?
Sure.
Oh, that's the other thing. Mr. Flynn's supposed to show up too.
Who?
For,
Oh, yeah,
for the declaratory ruling, but it's the last item, so maybe you won't get to it right away.
We're going late today.
Okay. All right, we'll start with 1558 and 1560.
Offer of letter of warning, accept.
Accept.
1559.
6,000. Charges sustained, 6,000.
I agree.
1561.
Offer of 750, accept.
Accept.
1562.
Offer 4,000, accept.
Accept.
1563.
I had a counter of 4,000. The adverse history.
Okay, I'll agree with it.
1564.
Offer of 6,000. I had a counter of cancel and bond. The violations occurred while operating under the temporary permit.
I don't have a bond because
Oh.
when they're operating under permit, they're not bonded.
Okay, cancel.
I'll agree with it.
Counter offer cancellation. Yeah. 1565.
3,000.
I agree.
1566.
Offer of cancellation and bond, accept.
Accept.
1567.
Offer of cancellation, accept.
Accept.
1569.
I have here cancel and bond.
As do I.
1570.
I was actually going down to 1,000 because they didn't know, or I believe that they didn't know when they did the second charge, so.
And the first charge was seems like a relatively inexpensive NFL football pool.
So
I'll go to 1,000.
1571.
Offer of 1,000, accept.
Accept.
1572 through 1574.
Offer of 3,500. I have here plus, I'd like to get them to add more security because it seems like it's all the issue. I had 5,000 counter.
I'll agree with that. He does say he's hiring more security, which obviously you can take with a grain of salt.
No.
1575.
Offer of 1,500, accept.
Accept.
1576.
Offer of 3,000, accept.
Accept.
1577.
Offer of 3,500, accept.
Accept.
1578.
Offer of 5,000, accept.
Accept.
On 1579, I had a request to adjourn by the attorney and to be placed on the 8/11 calendar because there are other disciplinary matters for this licensee then.
Is this the one you were talking about, Mike? Yeah.
Yeah.
That's okay with me.
Okay. 1580.
Offer of 2,500, accept.
Accept.
Okay. Mr. Amaretto, are we sectioning out the workers' comp cases, or this one is actually fine?
I'm sorry?
The workers' compensation cases, yesterday council would like, she was noting that when they appeared, she wanted them returned to council.
Oh, I wasn't aware of that.
Okay, no, but, all right.
Oh, we should probably set
This one, well, this one though, I think is.
1580, right?
We're on 1580, however, the offer was
2,500.
in line with what council was
Okay.
looking for. Okay, we'll
That's
leave that, but we'll try to
Yeah.
see if you can.
Pull out the other.
Yeah, for consistency purposes. 1581,
Offer of 1,000, accept.
Accept.
1582,
Counter of 10,000.
Okay,
It's the third
I
sale
agree with the
tonight.
10,000.
1583,
Offer of cancellation bond, accept.
Accept.
1584,
Offer 1,500, accept.
Accept.
1585,
Offer of cancellation bond, accept.
Accept.
1586,
And they've been evicted, cancel and bond.
Cancel. I agree.
1587,
Offer of 5,500, accept.
Accept.
1588,
Offer of 3,000, accept.
Accept.
1589,
500.
500.
1590.
Counter of 2,500.
They provided an ATAP certificate of completion showing that the clerk was certified at the time of sale.
Mm-hmm.
So that's where the penalty will fall under 65-7A, where we're limited to the penal sum of the bond, which is
Yeah, that's
1,000.
why I have 1,000, right?
Okay.
That's what,
yeah.
1,000,
All right.
yes.
And
So
it was-
if they've had ATAP certificate training and they sell to minor afterwards, they are limited to 1,000?
We
The
are
first
limited.
one, right?
Yeah,
Okay.
first. Okay.
So 1,000.
Yes.
Yes.
Accept the offer of 1,000.
1591,
I had 7,500.
I actually had 8,000.
8,000.
1592,
What do I have here? I said okay. Oh, charges dismissed.
I dismissed, yes.
1593,
6,000.
I'll agree.
1594,
500.
I agree.
1595,
Cancel and bond.
Yes, I agree.
1596,
3,000.
3,000.
1597,
2,500.
I agree.
1598, and 1599.
Offer of cancellation of the license and forfeiture of the bond, accept.
I accept as well.
1600,
6,000.
counteroffer?
Yeah, counter for 6,000, please. Offer was for,
I agree.
offer was 5.
1601,
Offer letter of warning, accept.
I agree.
1602,
I have a question on this. What's the status of this license? Because I'm,
The food.
it's going to be canceled on the 3rd, to see if it was canceled,
oh, no, so it's going to be canceled on the 13th.
which was,
So we're basically,
Let me
so
just-
we're revoking no bond because there's no bond available?
there's no bond available. I have it crossed off here.
So it's just
Let me
cancel for the
Make sure that
record.
they posted it.
So this is canceled for the record? Okay.
You can cancel. Oh, yeah, they're making an offer of 6,000.
I
Well,
don't
if it's accepted and they don't pay, it
Still gets
converts
canceled
to a
anyway?
canceled bond.
So if they're getting canceled and they're offering 6,000, we might as well take the 6,000.
I agree.
Although they're not going to pay it.
Oh, let me just see if the other, well, the other was a 5.
I'm glad I was not the only one confused.
You are not.
Yeah,
Usually in company when
that's
that
fine.
happens.
Yeah. 1603,
Offer 5,000, accept.
I accept.
1604, and 1606.
So charges 1, 8, 9 in the first proceeding and charges in the second proceeding are all sustained. Charges 2 through 7 in the first proceeding are not sustained. And I had cancel and bond.
I have cancel and bond too, mostly because he sold the business with the license
And the charges as
without
enumerated
telling
are
anybody. And the
dismissed.
charges are, yes,
Got it. 1605,
Offer of 1,000, accept.
accept.
1607 is a workers, yep, yeah, but
Okay.
the offer is,
In line?
Yes, it is actually,
It
isn't
is
it?
in line? Okay.
Well, it's 36, no, it actually isn't. She said
2,000, we said 2,000 and then 500 per month, right? So
she's
let's
at 36
do
months.
36 months? Wow. That would be
So
quite a
do the
lot.
math. You're the advocate.
6,000, I got it. 8,000.
do you want to
36 times 5, 12, 36 months, right? 36 months times 500, right?
18.
Oh my gosh. Huh?
It's 18 then.
Yeah, it's a lot more. So 36 times
So we're-
5. Yeah, 18, and then 2,000 on top, so it's
We can't do that much, though, can we?
20,000.
36. Shoots that theory down.
There goes that, yeah. Maybe we should put this aside.
Yes.
Figure this out later.
Well, how, return to council?
Council, yes.
How's that, return to council?
Because I guess there is a limit.
There
right?
is a
'Cause it's
limit.
10,000
Which
per
we didn't-
charge,
we didn't-
We shouldn't factor that in yet.
1608.
Chief of Police says okay, so offer 15-day suspension forthwith plus 10,000 accept.
Accept.
1609.
I have 1,000. See, violation occurred within the 5 years, and second time.
The problem, the question I have is, our office is telling them to ask for a waiver, even though the waiver doesn't have any legal effect?
The waiver allows us to issue the license, so that don't go without the
Okay.
license, but they still get hit with the penalty.
Okay.
For not notifying timely.
So, and
They do get
what,
confused. They feel that the waiver also alleviates this violation,
Okay.
but it doesn't.
and what was your offer?
I had 1,000.
Okay, I'll agree.
Second violation.
1610.
Cancel and bond.
I agree.
Accept,
Oh, yes, accept.
because it was a 500.
Oh, it's a
canceling
500 bond, or do they have?
Unless they're
All right, well,
all
I'll-
civil, it will convert to a bond, but it was not a full.
How much is the bond? 1,000? So they're trying to get
1,000.
500 back?
Yeah, I think.
That's really what they're
We're
trying
not
to do,
going to
right?
pay them $500, but they're, if it's accepted, it's cancellation, and we'll demand 500 of the bond. If they don't pay the civil.
Okay, all right, we'll accept the offer then.
500?
I accept too, yes.
Okay. They're already out of business.
Yeah.
This is a workman's comp board.
1611, I have a request to adjourn to 7:21.
And this is a workman's comp, right?
Among other things.
Among other
Let me
things.
just see
So
who-
721?
Well, if it's not a single workers' comp case.
Right.
All right, do you want it returned to council, or do you want it carried over?
We'll carry it over.
Yeah, because by
All
then,
right.
hopefully we'll.
Okay. 1612,
Offer of 2,500, accept.
Accept.
1613,
Offer of 1,000, accept.
Accept.
1614.
Offer of 1,500, accept. And the only reason was because, I mean, they've been licensed since 1940, and they had no adverse history for, what is that, 75 years?
Our computer records only go back to 1988. So
1988.
they're still clear from
They're still
1988.
pretty clear, so that's the only reason why. I mean, they didn't call the police, and I was bothered by it, but
I accepted. 1,500.
1616.
1616.
I got cancel and bond.
Yep, I had revoke and bond.
I'll go with revoke.
Revoke and bond.
Yes.
1617 through 1619.
Okay, offer 4,000, accept.
Accept.
1620.
Letter of warning, accept.
Accept.
1621, I have a request to adjourn, and also I'll clean the agenda. Charge 4 does not exist.
Sure.
It was
Yeah.
just left in the system.
Right.
The attorneys asked for an 8/11 adjournment. Well, the chairman granted that one back in the office. 1626.
1626. El Nuevo. Offer of 7,500, accept.
Accept.
Okay. Okay, 1628.
Right, can I, one question on that El Nuevo. Are both levels licensed? They have like 2 levels.
On Mirror Lounge?
Mirror Lounge. Are both levels licensed?
There's no ad bar, but let's see what we got. I'll get that. Oops. Diagrams.
Hey, Carrie, did you hear from Mr. Levy?
Nope, not yet.
Mr. Levy.
Very unusual.
Block diagram, there is floor, lower level.
Both a license?
It's in the diagrams. One bar
Go into
there.
data, maybe it shows on the data. 2 bars.
Okay. I think it might be listed there.
Yeah, there or the digest.
Bar survey, recorded music, nope. I don't think probably the digest was there too.
Should be scanned in or, yeah. Tells you nothing.
Tells me nothing. That's old.
Yeah.
Try another one. There's this one.
That's better.
You
Next
know.
page.
Thank you.
While you guys do that, I'm going to take a 2-minute break.
Okay. 2 floors.
Okay.
Mr. Levy is on his way.
All right,
Did you solve
Right.
that 2-floor problem?
on 1626. the
Okay.
item's still on.
Great, thank you.
Okay. And so it's accepted?
Yes.
Okay. 1628.
Request.
I have a adjournment to 7:21.
Okay.
1629.
Request for reconsideration, deny.
Denied.
Okay, we'll reimpose the order. You stayed this one, okay. 1631.
A request for reconsideration, denied.
Denied.
Leave that out. 1632.
Request for reconsideration, denied.
Denied.
Typos everywhere. This is horrible. 1635.
Cancel and bond.
Cancel and bond.
I have no bond, I'll just cancel.
Cancel.
I can do that. All right, 1636 and 1637.
Offer of 6,000,
All
count.
the council's requesting the item to be returned.
Okay.
1638,
So, so I don't need this, that's going to come back to me?
in a different form, yes.
Okay.
1638,
Cancel and bond.
Cancel and bond.
1639 and 40,
Offer of 8,500, accept.
2,500.
I'm sorry.
This is 1641?
No, 1639.
39 and 1640.
Huh?
$8,500 offer.
But I have it as a third. Oh, 1, 2, 3, 4. Oh. Good catch.
Oh, I got
Hold
it.
on. Hold on 1 second, please.
Well, that's my question. Was the sale, was the store, the location notified of the 4 sales or of the 3 sales, or were they notified at the third sale of the other 2? You understand what I'm saying?
Right. I think that's why it's accepted this. On each of the instances?
On July 24th,
Okay.
on September 6th.
Oh, so they were given summons or arrested for each of those 3?
What I'm saying is the NYPD was involved.
Right, but you know how sometimes NYPD does it and then they do it all at once?
If it was a nuisance abatement, there's no indication in the CNC memo that it was but I could double check.
Yeah, maybe double check, because I assumed that they hadn't gotten notice. Which
As-
is why
as did I,
accepted it.
which is
But if
gonna
they did
affect-
get notices, this would be cancel and bond.
I'll see.
So set that aside, maybe, while he's
All right.
looking.
1641,
1641, offer of 2,500 was low given their history and in a 20-day suspension. And
What had happened in this case, the counter offer letter went out after I did the CNC on this one. So I wasn't aware that there was a counter for suspension.
1641?
Yeah, he's saying that the earlier one where the suspension was, he wasn't aware that the counteroffer had gone out on that before he made this actual offer.
Right. The
Oh, I
counteroffer
see.
went out on 6/26. I prepared this on 6/24.
I see. And what would your offer would have been if you had known? Yeah, that's what okay. So
counteroffer.
counteroffer of cancel and bond?
I agree.
1642,
Just offer of 750, I thought was low. I had 1,500 counter. They can't employ a police officer, correct? That's
is it a rule?
off-duty police officer can't be.
I'll agree with the 1,500 counteroffer.
No,
Right.
not. Okay.
I just heard from Mr. Flynn, I guess there's crazy rain and flooding, so he's about 30 minutes away.
It's raining?
Outside? I guess it hurts you more than me. Crutches.
Yeah.
1643 and 44.
Offer of 7,500. I have a counter for cancel and bond. This, they did get summons for the first proceeding, second proceeding, and then this is their 4th.
Yeah,
violation
I'm fine with the cancel.
Within 2 years, 3 years, 2 years.
1645,
Offer 5,500, accept.
Accept.
1646,
I had a count of 3,500. The daughter of the licensee instigated the fight on premise.
I'll go with that. The daughter is, I just want to point out she's apparently mentally ill.
Okay.
But I'll go with the 3,500
okay.
counteroffer.
1647,
This is an offer of 4,500. Thought it was low. 6,500 counter.
I'm fine with that.
counteroffer.
Yes.
1648,
Okay, this one, the 2 sales to minors was on the same date. Offer of 8,000. I'll accept.
I'll accept as well. Now, Mike, let me just ask you a question. That's on the same day, but actually an hour apart. Is that the NYPD as well?
this is Oneonta.
Oh, it's Oneonta. Okay.
1648.
I didn't read the address. Okay, that answers my question.
1649,
Offer of 750, accept.
Accept.
1650 and 51,
So I had a question about the second charge on the second proceeding, disorderly premises. I wasn't fully convinced that that was the right decision.
I was not either. No, I had a problem with the first charge on the first proceeding.
As well? So in this case, when we're actually differing with the ALJ.
I question in the first one whether.
If you can just dismiss those charges.
Yeah,
Or withdraw.
I'd be okay. Are you okay?
So which one do you want dismissed?
The one and two, well, the first one in the first proceeding that you were talking about. That's what you're talking about. You have an issue with?
Yeah, that nobody ever saw the guy drinking.
And then the second one, the disorderly premises.
Mike, you had a problem with this too, right?
Yeah, perhaps maybe alternate findings, have a
Alternate findings. Okay.
Do you want to have a conference?
Let's have a conference.
Let's have a conference.
No, I mean, you want to dismiss 3? I'm fine with that.
No, let's have a quick conference.
All right.
Yes.
On 1650 and 1651?
I believe we're going to ask for alternate findings on all 3 charges.
Agreed.
Got it. 1652.
Offer 4,000, accept.
Accept.
1653.
Offer of 6,500, accept.
Accept.
Okay, the other I have was rescheduled from yesterday. It's the request for a declaratory ruling with Mr. Flynn had requested the item be moved over.
All right. I mean, I was okay with the
It's
grandfathering.
Yeah, I was as well.
Okay, so
I mean, we don't need him.
Yeah.
You sure?
Yeah. I mean,
We agree with it.
You agree
with
that-
thing. So you could even just let him know if this is all he's coming in for.
Yeah, he's on his way. He's not going to turn around now.
Okay, so it's going to be either grandfathered or it's continuously licensed, so the 200 foot.
I'm saying that
does not apply.
Right, I agree. I'm saying it doesn't apply because it's, I'm going to say it's continually licensed.
I agree.
Okay. Then we still have, well, we have a, but you wanted information on 1639 and 1640.
Yes, 1639.
That was not part of a nuisance abatement.
No, it
was
wasn't.
of arresting officers' information. So apparently they were on notice when the individual was arrested.
On the 816, there was a person arrested on for the 816 incident, but the one before, they don't have any information, like you said. There's no information as to who was the clerk involved. That's left blank for the 8.8 incident.
Is Buckley up there, Mike?
I'm not certain. I could check.
Would he know if we asked him?
When's this coming up?
I would hope so.
I thought it was.
721.
What?
10721.
Why don't you go check?
Yeah, I think.
Go check, because we want to know if you understand the question. Okay.
Oh.
Right. We want to know if they were on notice.
Yes, 721, sorry.
Why ignore? Yeah, it's hard to tell if this is actually a school or not.
Yeah.
Because it just has a
The
person.
building, you'd have to see the building.
Yeah, I
It's
saw
not
the, well,
right.
you saw the picture. It says,
Should we go?
Yeah, we
can go off the
we're in
record
short
while waiting.
recess.
Right?
Yeah, short
Recess. Okay. You want to call Ms. Lee?
Okay, we're back. On 1629, is that it?
23.
23.
Yes. So
Oh, yes, got it right here.
Get out.
1623, it's 1910 Waterfront.
Good afternoon, Joseph Levy here on behalf of the applicant. Apologies again for the delay. I know we have some opposition here from the community board, so if you'd like to hear from
Yeah, we actually heard from her.
Okay.
So the main issue was, I think she's just like, why aren't you responding to them?
Sure. So I've read the materials that the community board sent in to the Liquor Authority as well, and I just wanted to give you, I guess, another side of this story. We notified the community board in January, I believe January 19th or 20th of this year. We received a communication, as the community board indicated, on January 26th, indicating that we needed to get all these things back to them, contact the Block Association, put everything together in 3 days' time. We were working on it. We were in contact with the community board. We couldn't get it done in time. They wouldn't let us submit anything after that to get on their agenda for February 10th. So we didn't make that agenda. Fine. We couldn't make it. We were going to wait. We weren't going to file our application. Indicating in the community board's letter that they have had no contact with us since then is not true. I have copies of emails that I'm happy to submit to you from my associate to someone in the board office indicating, hey, we couldn't appear before you in February. Just want to make sure we're on the calendar for March. No response. Number of calls to the office, no response. March agenda came out. We weren't on it. At that point, we had a sale of assets here. We had a sale of a building to a different party, real estate sale, and we had to file our application because there was another application that was expiring, They didn't want to renew it, and if we didn't file within 30 days of when it's expired, we lose the ability to transfer a license that's been in place for over 50 years. So this is not a 500-foot rule case, and that's significant. These grandfathered licenses are few and far between in New York City, with no stipulations and just no need to go to a 500-foot rule hearing, so we didn't want to give up that privilege. So in March, we filed our application with the authority, transfer. We're issued an ST license. The operator's been operating since then. Restaurant use, similar use to what was there. Christine did reach out to me in May to ask me to get some materials back into them so that we can appear on the June meeting. I thought my staff was putting those things together. They weren't. Then we found out from the Liquor Authority that this was going to be a full board case anyway. So the fact that it was going to be a full board case anyway and we couldn't get stuff to them for the June meeting, that was going to push it to the July meeting. And then if that didn't go well, now here we are in August or September or later. So for me, it was a decision really at the last minute. We're going to hash this out at some point. I don't think that we're so far apart in what's wanted. I think, you know.
Well, what are the issues as you see them with the community board, as far as what your business operations are?
I actually don't see any issue with method of operation in terms of the fact that this is a restaurant. Same number of seats there were before. Very well-known chef, runs a tight ship, and since they've been open for the last 3 or 4 months, they're regularly closing at midnight. So it's not a late-night establishment. The issue is, as I see it, the community board's going to want to put stipulations on this license with respect to hours. Now, they're within their rights to want to do that. The fact that this is not a 500-foot rule case, and it's a grandfathered location, and it's unrestricted as to this point and has been for the last 50 years, that's something of value. And I don't know that we want to give that up if we don't have to. Now, you've seen this operator, or maybe you haven't seen it, but the operator's been there operating his restaurant for the last 3 or 4 months. No incidents, closing early, and that's going to be his regular course of business.
What's the latest he is open on the weekends?
So far, he's been closing midnight at the latest. However,
not enough business, or just?
Well, it's summer. Summer's always slow in New York City. This is a chef who's very well known. He was the executive chef at a number of other big restaurants in New York City. This is his first project. It's solo venture, tough to do. His whole staff of the old place walked out. He had to bring staff over. Some of them wanted to leave, some not. So it's been kind of touch and go. So he doesn't want to extend himself too much. He's trying to do this the smart way. Again, a guy with incredible training, great track record. Once we hit the fall and people come back to the city from out east or the shore, wherever they are, he's going to want to expand what he's doing. However, is this going to be a bar? Is this going to be a club? Is this going to have a DJ? These kind of things? Absolutely not. I'm happy to stipulate to that.
And you have every intention in the future of meeting with the community board and trying to hash this stuff out?
Absolutely.
Okay.
And like I said, this is the only issue. And, you know, once we get into the holiday season, private events, corporate events, birthday parties, this kind of thing, there's always not enough hours in a day to do those things. Is this guy going to have a party starting at 3 o'clock in the morning? No. He's, you know, recently, you know, married guy, young guy, family. He's not looking to be out till 4 o'clock in the morning. And he is a decorated chef, and the space is built as a restaurant, and it intends to stay a restaurant. There's no change in method of operation here. The only real sticking point, as I see it, is they're going to want to restrict the hours here. We don't want to because it's a thing of value, and there aren't a whole lot of them left in New York City.
Okay. Ma'am, do you want to add to that?
But just quickly, what about the landlord getting a percentage of sales?
So I indicated in the application that that was going to happen, and it's kind of been an ongoing negotiation here. And a lot of that is going to depend on this also. They're going to figure out they're either going to readjust the monthly rent, readjust percentages, or whatever it is based on what the operation's going to be. So if you'd like, obviously, I was anticipating having a newly executed amended lease as a conditional item. This would basically act as like a letter of intent, which normally would be accepted.
Do you know what the maximum percentage might be?
I've made them aware of the threshold to come back here before the board, and it's going to be below that.
Which is generally 10%.
Okay, thank you. And just a quick question. So this grandfathered license, that's just a unique category that's still existing?
Well, what happens is it's been licensed since before 1993, so the 500-foot law does not apply.
Okay.
When they are, if I'm the seller, I'm using my
Right,
4 or
it's an
5
asset,
hours
right.
as a reason for you to purchase it.
Okay.
So,
As well as the transfer part of it.
To get the temporary permit.
So this license you can just transfer without our approval?
No. They have, it's still a new application.
It's a new
The
application.
transfer is kind of an internal title.
But it allows, it means
allows
that
for the
the,
temporary
and the
permit
500-foot doesn't apply.
The 500 foot doesn't
Okay.
apply.
Right.
Yes.
Allows you to immediately operate under temporary
Yes,
license.
correct.
Right, whereas the others, you gotta get ours before you can do it. Okay.
Question for clarification, it still allows to change the stipulation, right?
Pardon me?
It still allows to change the stipulation, the grandfather.
Oh, yeah, it's still a new application, so you can
Okay.
still discuss, yes.
But it's not a 500-foot rule case
No,
at
I
this point?
understand.
Okay.
I understand that. So I think we heard this gentleman. It's possible that our staff has been deficient for 1 month, but I know I have not been deficient in calling this gentleman and at a point of time not getting answers anymore. So I do know that because I tried to call multiple times and I emailed it multiple times and I didn't get emails back. So that's one thing. The second thing is that you heard that when September comes, the applicant will be happy to expand the hours so he can do more money. And then I think we have a very good setup here for the owner of the building to push the applicant to do more business and more parties, etc., in order to get more % of the sales. So in this environment, you know, if I don't see any reason not to limit the hours at least to midnight during the week and 2 o'clock in the weekends. And so that when you have 60 or 50 or whatever the number of people coming out at night, if they have parties, it's very loud. And it's really the kind of stuff that really disturb the neighbors. There are a lot of 3 and 4 floors building around there. And it's not a fun. It's not a fun environment.
I understand your arguments, ma'am. My only, and you know, I asked you the question about Moran's, who was there for obviously decades, and it sounds like to me, based on your description of Moran's, that right now, at least for the last 3 months, and it hasn't been summer for the last 3 months. It's only been summer for about one of those. That this restaurant is operating almost identically to Moran's. And you indicated that you did not have a problem at all with Moran's.
You know, change of owner is a very
No,
different.
and I understand
so I
that.
wouldn't make any I wouldn't make any parallel between Moran's and that. This is a new owner, this is a new lease, and there are new incentives.
No
So
question. But right
so
now, everything he's shown you is
right
that
now
he
is
is
fine, and that's why I've suggested that if he can constrain by stipulation this business to be what it is, I'd be very happy.
But I'm not. I don't know that that's necessary is my point at this point, especially when he has indicated to you that he's going to come and meet with you, and if there is concerns, and I would make the license conditional on that fact, that Mr. Levy and if you need to see the owner as well, meet with your community board and rehash these things. But I don't just want to put a stipulation on a place that actually has value. It does have business value, and there's been no indication that there's a need for it right now.
He has only business value if they use the 2 to 4 o'clock hours.
No, that's not correct. It has business hours should this individual ever want to sell this business in 2 years or 3 years. It does have value. It doesn't mean that you'll agree to it at that time, and it may be another type of business. At that point, that person will have to come in here, and perhaps we would stipulate the hours. But based on what he's describing this business is right now, I don't see the need for it. And I would like them to come and meet with you and discuss this issue. I don't know what your thoughts are.
I agree.
I mean, as
So you
long
want
as he
them to
comes
come
in.
before they get the approval? Because we've been trying for.
Would you want him to discuss if we are not stipulating?
Well, if they do have issues with it, right now it sounds like you have no issues with this business.
No, we have
so-
no issues, but the problem, sir, is that we have many restaurants where we don't have issues, and then they have issues, and then it's extremely difficult. First of all, we have hundreds of residents which are inconvenienced, right, and sometimes not sleeping, and then we have to take our time as non-paid employees and to deal with it, and it's
I understand.
not our job.
I do
So
understand.
what you are
that.
doing is putting the burden on us when at the time of the application, what we are trying is to establish the line to not cross so that we don't have those issues and we don't have to deal with this. We are approving about 17 or 18 or 20 applications every month. It's overwhelming.
No, and I understand
and
that.
My last quality of life meeting went until 11:30 because we are discussing with each of those applicants, which are maybe 5 blocks away, and not doing the right things because they sounded like they were fine. So I'm sorry for the emotion, but it has been a long time that we are fighting with those issues. It seems to me that it's a very small give to the community. If their plan is really to work as 12 and 1, 2 o'clock should be perfectly fine.
And I don't disagree with you, but my point is that there's a value to the businessman, not to stay open, but the ability to sell that possibility to somebody else. And I don't want to take that asset away from them without reason. And speculating that this individual who's given you no indication that he's going to violate any moral compass that your community board may have, because he's been in business now in this area for 3 months and there hasn't been an issue. And it sounds like he's closing 2 hours earlier. Now, I realize going forward he's probably going to want to stay open 1 o'clock, possibly 2 o'clock. But this sounds like it's a place, and based on the representations the attorneys made, it sounds like it's going to be a very nice restaurant that has no interest in violating any type of noise issue with your community board. If there was an issue, I would be the first one to put a stipulation on it, believe me.
So is that part of the stipulation, that if there is an issue, we will put the stipulation in?
You certainly can come back to me if you want. I mean, I don't know that Mr. Levy has a problem with a year down the road revisiting this.
Yeah, I mean, my only concern at this point...
Go to the mic,
Just come to the podium.
My only concern at this point is if we go back to the community board, which I'm happy to do, the crux of our conversations at the community board are going to be on our stipulations, which is what we do not want to do. I'm happy to stipulate to the method of operation. I'm happy to stipulate to the occupancy. I'm happy to stipulate to a number of different things about the operation. What I do not want to stipulate to, and I certainly don't have the authority to do so today, is to restrict the hours any, because as you mentioned, Chairman, this is a thing of value. It's a thing of value to the chef and owner. It's a thing of value to the gentleman who just bought this building for a tremendous amount of money. It's a thing of value to anyone in New York City because this grandfathering of the 500-foot rule is significant. So if that is going to be what we're going to talk about at the community board meeting, I don't necessarily see a reason to do it. I'm happy to go meet with them and introduce them to my client and do the outreach. And just for the record, I thought that was a nice thing to say. Just for the record, when we originally started this process with the community board, we did reach out to the Block Association, whose information we were given. We told them what we want to do, who it is, blah, blah, blah. Never heard back. So if this is something that everyone is so incensed about, I think more people might be here, and the Block Association would have responded.
There's also, they come up for renewal.
Right.
Every 2 years.
Yeah,
and
on
there's
renewal,
also,
if
if
we
they're a
have an
bad
issue,
operator,
we'll
there's
back
also
you.
the ability to say we're not going to renew without stipulation.
Well, you have any questions, comments?
Yeah, no, so basically, I've been in your position. I've been on the Quality of Life subcommittee for CB5 for several years, and we've had very long meeting with good operators and bad operators. And so I'm sympathetic to what you're saying. I think what the chairman is saying and what I am kind of leaning towards at this point is that those bad operators that you spend time till 11:30 talking, when they're up for renewal, that's when we want to really know about everything that's gone on, and that's when the time to act to deal appropriately with the bad operators so that you're not flooded with that burden on the community. Excuse me?
Charges too. It doesn't have to wait for renewal.
Right. It doesn't even have to wait till renewal, but if you can give us a list of those bad operators too, we can help with the enforcement part of it as well. So that's people who've already been a nuisance in the community or people who aren't abiding by stipulations they agreed to open up businesses. In this particular case, if you're talking about somebody who's coming in and operating in a manner that's not currently causing an issue, it's kind of difficult to come in to take a legal right away from somebody who has this valuable asset, which is this grandfathered license. I mean, that's why I asked that question, because it's a special category of licensing that I didn't know of before today. And so understanding that from a business perspective, that there is a value to that, and nothing's been done up till now to abuse that privilege, I think that it's difficult for us at this time to impose any kind of stipulation on anyone. I do think that Mr. Levy and his client and maybe the landlord, they need to go in and stipulate to the method of operation, to all the other stipulations that are in there. The hours discussion, I don't think it'll be fruitful at this point for there to be further discussion. I think they understand you would, like a midnight or 1 a.m. on weekdays max, and then 2 a.m. on weekends, and to the community board, that's reasonable. But just because of this unique category, and because it's not a 500-foot hearing, a 500-foot case in this situation, it's just difficult for us at this time to take actions limiting hours on this particular case. So that's kind of where I'm thinking, and I think I would love for the two of you, the community board and all the block associations, to sit down and stipulate to everything else, and then the hours, we'll soon find out if it's going to be an issue or not. And again, I know to you it's like one more, and there's already 6 others that we're dealing with, but it's those 6 others that we really have to go and address immediately. And please, Mike Jones, who was here, and he deals with the community board, and you know him, I think, and please give him a list of the bad operators so we can act on that even before renewal, but especially to build up the case against them when it does come for renewal, so that the burden doesn't totally fall on volunteers like yourselves who spend a lot of time out there for the community. But in this particular case, again, that's my thinking.
Sure.
And I hear what you're saying. Is it a rule that the community board, that the applicant should attend the community board?
No.
Not in this instance, no.
Okay.
It's statutory that they notify you. It's not statutory that they attend, but we will always, make that recommendation, but more so if there's issues with the location.
They have a right not to attend the community board, but obviously, and Mr. Levy's indicated he's happy to come see you. Here it sounds like it was a time constraint because there was a transfer of assets and they needed to do something about it, which I understand.
There's a special category of license, I think, in this particular, and the emails that went back and forth, he says he has proof that he emailed your staff and they might have missed it along the way. But you personally emailed him, and I don't know about that, Mr. Levy.
Response 3 times.
At that point, he knew he was coming here.
Board case, and this was going to happen before that, so what's the point?
But it's always probably good to reply to an email to a chairwoman of a community board.
I understand, but I'm also mindful. So,
Yeah,
by the way.
I get it.
Okay. I don't
No,
know.
anyway, so the point is, I think, you definitely have to meet with them to stipulate on all the other
100%.
things aside from the hours. And
we're going to be for a sidewalk cafe in the next month or so. So it's the same committee. It's an opportunity for everyone to meet.
We can make him stipulate right here today that he's going to, the method of operation. I can just add that right here onto the record.
Yeah, it's in the application.
Well, I don't know whether she's had a chance to review it, have you? The method of operation and everything else that he talked about besides the hours. Have you read it and are fine with it?
I don't think we have a problem with that, except maybe for the recorded music.
Okay, then if you're ready to stipulate to it, we can do it now.
Yeah, I mean, I'm not up here selling you a bill of
recorded
goods.
music meaning you don't want DJs and things like that, obviously, but what do you mean by recorded?
Background ambient music.
It's background.
And he's willing to stipulate to that, it seems, so, okay. And you're okay with that?
Yeah, I'm fine with that.
Okay, so everything seems to be,
Most of the time they would operate until, a certain...
well, again, the hour discussion we'll set aside for now, and everything else, I think he's willing to stipulate to what you were talking about, so I think we're...
So now, do you need him to come to the community board and meet with you guys? Because he's stipulating to all of it now except the hours.
Well, we're going anyway for the
Okay.
sidewalk cafe. So we're going anyway.
But that does include the sidewalk cafe.
Does not.
This does not include the sidewalk. That's a completely separate...
Inside, yes. So, Joe, I'm going to just say you're going to be a restaurant
Restaurant, yep.
with ambient background music.
Yep.
No, what's your legal capacity, maximum occupancy? That wasn't on the establishment question.
And the least percentage issue you're going to raise with the
Yeah, you
landlord?
can make that a conditional item, and I'll get you a copy
If
of
it's
that
anything
stuff.
over 10%,
Yep.
then we're going to have.
I know, we'll be back here. I think there was a C of O issue, that's why I left the occupancy
Okay, that's okay.
open, so I can just email you what those specs are if that works for you.
No dancing,
No, no dancing.
No DJs.
No DJs.
Yep.
no outside area right now.
Well, hold on a second.
Is there an outside area in that area?
There's a transfer of a sidewalk cafe that's existing.
Yeah, but you don't have an outside area right now.
I don't think I have one on here because we haven't had an approval yet, but that approval is pending. So
All right,
that,
so for right now, there's no outside area.
so that will be, I mean, you'll get an alteration.
That'll be
on
an
that, yeah.
alteration application, so that's fine.
Yep.
No outside area. Anything else that, am I missing anything?
Live music?
Yeah, we say no dancing.
No, yeah, there's no
DJ,
cabaret license, so.
No live music.
Well, I'm
Yeah,
just
there's no
gonna
cabaret
put
license.
ambient background music only.
Okay.
All right, is that, okay. Now you have to vote.
Oh. So with those stipulations, I approve.
With the stipulations, I approve as well. And with the understanding that when the renewal comes up, if the community board does have major issues with the hours, we'll revisit it at that time.
Okay, thank you.
Okay. What's that?
Do we find 163940 yet?
Yes,
The-
1639, it appears
okay.
the first three were part of a nuisance abatement. It doesn't look like he had notice by
Okay.
the time he got the fourth one.
Okay, so I'll take the 8500.
I'll take it as well.
Thanks.
Okay.
The offer.
And Mr., where's my other item?
Which one? Oh, the Billy Marks?
What number is that?
It's 1629.
All right, 1629. We're going to recall it since the
Oh,
board
can I see
had
that?
Yeah.
previously voted to deny reconsideration.
Joseph Levy here on behalf of Billy Marks West. This was a decision by the board previously to cancel this license. I just wanted to go into a bit of the procedural history here, as I think there was maybe something that wasn't completely clear. Back in February of 2015, there was a conditional no contest plea submitted, or heard by the members rather, for an alteration and not having food and a few different things. The chairman at the time required the presence of my client. This was handled by an associate of mine, just to make sure he understood that not having food was a serious thing, or not having food at the moment was a serious thing, and alteration without a proper alteration to the authority was a serious thing. And he wanted to make sure he understood that he doesn't want to see him again for future infractions anytime soon. Fast forward to May of this year, my client had a matter on the agenda before the members, and Commissioners Kim and Green decided to cancel the license based on the fact that just really 3 months prior, they just told this guy, please, no more violations or we're going to take this license. What I wanted to bring to the attention of the members, and the reason for my requesting reconsideration here, is not so much a controversion of the findings of the ALJ in this case that was adjudicated, but more just the timeline. This was a case that was a violation that occurred in May of 2014. The case was went to a hearing, and the hearing concluded well before the February 10th meeting here before the members. So when the members decided to cancel this license in May of this past year, based on the fact that there was a next in time infraction after they just warned him not to have any, I wasn't here personally to make that distinction that day, because I figured this was just going to be a civil penalty based on the fact that it happened a year previously. This wasn't something that happened right now. So the reason I'm asking for a reconsideration is this is a gentleman who's been in business for a long time. Is the history great? No. But this was a case that went to a full hearing a year ago.
I found mine.
And there's a civil penalty. We're happy to accept it, but a cancellation, this was not a next offense in time. This wasn't him not listening. There's been no offenses. There's been no violations since he was here, since he's fixed things, and he's really making a concerted effort to tighten things up. He's been in business a long, long time, and it would be a shame to have him lose his license on the one charge. I understand the one charge is not, a trade name issue. This is significant. It was a sale to minor. But I'm sure you've seen the controversies that are in the file about the actual case themselves. And like I said, I'm not here to re-argue the case. I'm not here to talk about the controversy or the facts. We're happy to accept the civil penalty, just a cancellation for really a lifelong business.
Yeah, I mean, I understand you pointing out the timeline, and I think part of the reason why I voted to cancel and bond was not so much the comment that, well, we just told you in February not to be before us again, and then we looked at an older in time case and then used that to say, well, didn't we tell you not to be here again, and that was your last straw. It's really the sales to minor history. 2011 April, you have one. You have two in 2013, March and May, and then this is your fourth one within a 3-year span.
4 years, really.
3, because the actual violations occurred April 2011, March 2013, May 2013, and then this sale to minor that was before us was May 2014, as you pointed out. So it's really April 2011 to May 2014, which is 3 years and 1 month. And so in that period of time, 4 sales to minors is a serious violation in itself. And so on that alone, I would sustain the cancel and bond charge. So even if this confusion might have confused or might have been perceived to be confused us, the time frame wasn't as important as the 4 sales to minors in 3 years.
It's, we were kind of under this impression that we were making this CNC for kind of everything outstanding, sort of like a global settlement to start fresh from here. And then to find out that a couple months later, something from a year ago was going to pop up, that's kind of the confusion for us. And like I said, I'm happy to pay a civil penalty. I'm happy to, make sure we all are on the same page with the fact that this is the last straw. And I'm happy to sit my client down and make sure he understands how serious these are. And it's kind of one more year out. But I would really...
So that's what I'm trying to think is that, if that third adverse history, the failure to comply and failure to conform to application on 9/25/14, that was the violation, and then the full board on 2/10/15 imposed a $2,500 fine. If this 5/1/14 sale to minor, which preceded this particular September 2014 violation, were in the same notice of pleading, and that came before us, would my decision have been different? And I would have said, instead of imposing the $2,500 fine in February 2015, I would have imposed the cancel and bond at that time, because it would have been lumped together in addition to the 3 prior sales to minor history within the 3 years' time. So,
I mean, he's had a really long history before that. I mean, it's not like this has been a sale to minor every year for 25
been around since 2000.
Years. So it's like, it's 15 years in business, and yeah, it's been a little rocky, but,
What do you think?
It's on you.
It's always
That's not my case.
I know.
You guys did it. I'm not gonna.
When are all my cases going to be done, and when is he going to be able to really start?
Well, you accept the civil penalty.
No,
here,
I mean,
and
if you
next time,
say
you guys
if
can
you're
all
yes, I'm yes. If you're not,
So it's.
So what I would say is, look, a lot of these, I don't do a lot of disciplinary work, as you guys probably know. I do licensing work. I am happy. I mean, I'll give you, my representation for what that's worth. That I'm happy to talk to this guy, send him a letter, make sure he understands that there's no more bites at this. It's like he's playing really a no percentage of error game here. I'd like to get him one more shot. He seems to have made a lot of changes, at least what he's telling us.
What kind of changes has he made?
In terms of security, hiring better people, having a better presence there himself. I mean, even
what about sales to minor in particular? I mean, what has he done? Well, you got to get him at the door.
So
that's
there's a door now. There's a door check and there's a bar check, as opposed to just one or the other.
Does he have a scanner? Because in May 2014, the officer didn't recall seeing a scanner.
I'm not sure. I'd have to ask him if he has a scanner. I know he's beefed up security in this place.
You can always make him get it if you're...
Yeah, well, that's...
2014, he was supposed to also have a video camera installed for these purposes. At the time of the May 2014 sale to minor, he said it wasn't operable.
Okay.
He also disagrees. He doesn't think that a sale to minor was even made on it.
Right. Like I said, I didn't want
to...
I know you guys don't like to rehear the cases, and I know that was one of the things that the police officer who said he came in with an undercover officer, he said he knows the guy. So he would know if he's undercover because he knows him. He's known him for years. So, like, I I don't want to rehear the case. I'm happy to tell him he needs to make sure his video equipment's good. He needs to make sure he has scanners on site. He needs to make sure he has, whatever security stipulations you'd like to see. But I mean, it's 15 years in business. It's his whole life, and
I don't know what's been going on the past 4 years. It's, if he had a clean record before that and all of a sudden we're seeing all
I
this.
think that's to the point of having more of a presence there. He was there every day, and then he stepped away, and now obviously things are tight, and he's coming back. So if he's back full time and there are still issues, then I have no defense for him.
Yeah, to me, it's what we just said to the Community Board 4 chair, which this Billy Marks, I think, is in Community Board 4. We said, we want to reward the good operators or give people a fair shot at being a good operator, but the bad operators, which is causing the CB4 members to work overtime in some respects, I mean, those are the ones that, we have to take action on. And so in this case,
Sure. I
just can't see 4 sales to minors in 3 years to change my vote to deny the reconsideration.
You can't consider the 10 years before that of a clean history as like a testament to the fact that when he's on site, things are different, and now he's committing to doing that more. And there are no complaints from the community here.
Here's the one thing I would possibly consider. Is, in the charge 2 where it sales to minors March 15th and May 23rd, 2013, did he get notice on each one, or was this one of those nuisance abatement cases?
But it was his prior?
Right, so it would be sales to minors on March 15, 2013 and May 23, 2013.
I could check.
Nuisance abatement.
It was nuisance abatement?
Yeah, hang on.
So they were lumped together?
Let me just check the dates, if I got the right ones.
So if we grant
Yeah,
the
those were
reconsideration and then
based
what?
on nuisance abatement.
Nuisance? So they were together lumped time?
Generally,
All right.
they do them in threes, don't they?
Do them in threes, usually.
So where did the third?
So they didn't,
This
you
one
didn't get
could be the
notice.
third
though.
one.
So maybe this is the third one, that's why they got notified.
That was
All right, well, so what if we grant the reconsideration, it goes back to us to impose a penalty? And this time you will have to participate.
No, I don't think.
You have my papers.
You can
There
take
was an
them.
offer.
Here, you
Oh,
can take
that's,
them, yeah.
that's, yeah, I found mine. Did you make an offer on this?
No, went to a hearing.
Right. So you can
Oh,
impose whatever you want.
right, so charge was sustained. So I do sustain the charge, and then we got 3 plus the history, but the max is 10,000, right? Third history, yeah, suspension. All right, how about a 5-day suspension and $10,000? Only because the two were part of a nuisance abatement and he didn't get notice.
I'm okay with that.
Will you accept that?
I'll take it
Oh,
back. to
take
my
it back?
client.
Okay.
Yeah, I can't make the decision myself, but I appreciate the consideration. What's that?
No, it's not an offer.
Yeah, no, I understand.
Oh, okay.
Okay, so they're modifying,
Oh.
granting reconsideration, modifying the penalty.
So what does that mean? So if they,
So if he can't pay it, he closes. Yeah.
oh,
Well, if he doesn't pay it, it's
Which-
10,000 goes into the revocation as an alternate penalty. That's our threshold for an alternate.
but if he disagrees,
He has no options.
he's just Article 78.
Yeah.
Okay. Thank you.
Thank you.
Worked for that one, Joe. You worked for that one.
Okay, Mr. Flynn came.
Oh, look at that.
Okay, I'm not sure if you want.
No, I don't need to talk to
Did you tell him? That it was
We didn't send it to him, but we can at least indicate to you what the board had voted on.
Good
This was
afternoon.
Yes, this was a short meeting. It's 15.
Very short meeting.
They're going to all be this way.
This is a new regime, I was telling everybody.
1659 Amazura, the board had voted to cancel and bond. Okay,
Was that a default? I just saw it.
that was the default.
Okay.
Default at pleading.
Okay.
It was a drug charge.
Okay.
Okay. The next was 1586. I don't know, Desmond Steakhouse. It was a non-bona fide charge, also defaulted hearing.
Yeah, that I wanted to speak to if I could for a second on that.
Okay, the board had opposed cancellation plus bond.
Right. There was a,
What number was that? What
Want to
number?
recall it? It's
if you would.
1586.
Yeah, he can recall.
There was a eviction proceeding that is being fought in court right now with regard to this premise. It is my understanding that the license has been placed in safekeeping. If you could check that, I was told that that was done by the...
The name on it?
Marshall. New York
Well, it
City
actually was taken by the marshal.
Okay.
And forwarded to
And
it.
forwarded to
Yeah.
you, okay.
Desmond
So the
Steakhouse.
marshal came in under eviction notice. That eviction is being challenged in court at this time. They did vacate the premise when the marshal came in. They had no alternative. They could not do anything other than that, but they hired an attorney, and that attorney did bring an action to challenge the validity of the eviction, and that's going on right now at this time. It is his intention to see that through and get back into the premise. So if you could consider a fine other than cancellation, because he's going through all the cost and expense of fighting this eviction to get back in, and the license will remain in safekeeping.
It's not in safekeeping.
It's just secured.
It's just secured, okay. And if, there's really no downside to the authority. If we lose that proceeding, then you have the license, and that will be the end of it. But if he is found to be correct, and that eviction proceeding is or was done incorrectly, and he gets back into the premise, he should have that license.
So the actual charge, non-bona fide charge was?
For being not open?
It's not being open
For
because
not
they
being
were,
open.
they were taken out by the marshal.
All right. So, I mean, I guess that's reasonable. If he's fighting it in court, I'm okay to keep it in.
Yeah, 'cause we have it
Keep
anyway.
it secured, we have it.
Yeah, I'm fine with that.
But not being open and not notifying us is
That was
a
wrong.
charge.
No, on that point, I don't disagree. He should have notified, but
You can give him a penalty.
Can we, all right, what will we call this? We called, okay, 1586?
Yeah, so are you changing your initial vote of cancel and bond?
Yes, so we'll keep it,
Well, you can impose another penalty.
right, and we're going to impose for the non-bona fide for not notifying us, let's see the history, 3 years, nothing, yeah, 2,500.
I'm fine with it.
thank you very much.
Was your request for a declaratory ruling, which was carried over from yesterday. The board had, they're going to issue a ruling that the 200-foot law does not apply.
See, he
Thank you very
should
much.
not show up on time anymore.
Just take your time.
Thanks very much. I just had one other question off. The Woodmere Lanes, did that get up? Yeah, did it get up?
I wasn't up here yesterday.
Okay.
What are you looking for?
There was a matter I discussed with council. It was supposed to be an added starter for today, Woodmere successors.
That was a summary.
Never discussed that with me.
Okay.
All right, let me see what I can find, if I can find it. Woodmere, that,
It had been a summary suspension where we had provided
That
new
is the
security
summary.
plans, worked out, offer a compromise in lieu of litigation.
62. It's not even scheduled for a future calendar. Let me just see if it's even written up. There. Was it for 2 proceedings or 1?
One proceeding.
One proceeding.
Yeah, so
Okay.
There was a summary
Yeah, I
suspension.
got the summary. Get your offer, July 10th. Civil penalty of 10,000.
Yes.
Yes.
And to see if it's written. No. Unless we just take it from the memo of the stuff to,
The only reason I ask is that, if I could just briefly explain, there was a summary suspension. This license has been around since, I believe, 1968 or 9, I believe, or it could be even
Actually
more.
60, it was before.
60? Okay, 60. So this license has been around a long time. There was a summary suspension. In lieu of doing an Article 78 proceeding, I had worked out with council. We put a detailed security report in.
Which was approved by the police department as well.
Right, which was approved by the police department. The police department came back and asked us for certain things, which we put in the offer of compromise. But a key cornerstone for us to the offer of compromise was not only the payment of the $10,000 civil penalty, which I have, but that it be for time served, because we've been closed all this time up to this date, and that's why it was important that it get on for today.
The summary suspension was imposed at board meeting June 16th.
Yeah.
So they've been closed since then.
So we've been closed just about a
Generally,
month.
summary,
Woodmere, yeah.
Woodmere, generally, premises that have been summarily suspended do receive expedited,
They do.
like expedited hearing or
And
expedited.
for time served, kind of.
I mean,
Right.
yeah, if their offer is, the only thing is you don't have any of the facts of what the case is. I could print them up for you if you want to give us 5 minutes.
It's up to you. What do you
It's
think?
up to you.
Just do it.
I don't see any issue.
All right. Okay. Let's
And
do
then
it.
we'll do it as an added agenda number.
Sure.
And I do believe you're intimately aware of what's going on with the police and everything
You can
else.
talk to them.
Yes, okay.
Right, because you did the summary suspension.
All right, so do we want to adjourn this and then, or not adjourn it?
Just
but
take a short recess.
Yes.
Thank you very much, I appreciate it.
All right. I need a computer. You're good? All right, well, back on the record. The board members granted your request to have this item put on today's calendar. It's marked 1655C. It's Woodmere Successors. Council, do you want to?
Yes. Basically, this was an offer of compromise that was presented. It went through council's office after vetting a security plan that we had provided. They contacted the police department. The police department wanted two other items that we agreed to and put into the offer of compromise. The offer of compromise also was for a $10,000 civil penalty, of which I have that certified check here today, and time served, which is just about 1 month from the suspension previously. So in total, it would be the new security plan, no use of promoters, the age verification system, and 10,000 civil penalty and a 30-day suspension, which has now been served through today.
What did the police department ask for, in addition to what you already had?
They had asked us that we don't use promoters, which we hadn't been using promoters, so that was no problem. We put that into writing. And they wanted us just to get an age verification system, which we told them we would, and we've ordered it, and it should be here within the week.
Now, this physical location, remember we talked about this briefly, they had a bowling alley on one side and then a room with, what was it, a nightclub on the other side?
4,000 square foot room that I observed.
Right.
I was expecting to see a little bar area inside of a bowling alley.
Yeah. I spoke with council about that issue. It wasn't in the offer of compromise, but apparently there have been some filings in the past. She asked me to make an alteration filing to make it just as it is, so the authority has that. I agreed to do that. And I believe yesterday the notification went out to the community board, and we have to wait to file
The
that.
alteration meaning
Reduce the size.
to
There was
reduce the
questions
size?
as to, there was one point in time when the size was increased, but there's a question of maybe the DJ got moved and how much it was, how big it was.
There's a significant amount of documents in CNG,
Right.
which is the archives, and I personally went through those.
Yeah, I know.
And this licensee goes back to the early 1960s. And apparently at one point in time, an alteration application was filed. It was to move the DJ booth. There was no indication either on the diagrams or on the application that they were extending it 4,000 feet. Then at some point in time, there was a fire, and I observed that.
Right.
But that's all the documents that I was able to see.
Right, and I went through that with council, and after the fire, they reconstructed the building, and they've been there since '60, and she asked that I file an alteration to give you exactly what it is, how it is right now, and I agreed to do that.
And does that include a 4,000 space?
It agrees, the whole place is the 4,000 square feet. It's the bowling alley. From the bowling alley, you come into the bar area.
How big is the bar area?
The bar area has a big room with it. It's about...
The bar area is within that 4,000.
Oh, within the
You have a
4,000.
dance floor, you have a bar area, and there's a pool table area.
Right. But the occupancy, oddly enough, the occupancy of that whole area is only 152, I believe it comes out to be. As large as it is, that's what the occupancy is. For whatever reason, I don't know. So that alteration will be filed to clear up that entire issue that goes back to some point in time between '60 and today.
Okay. All right. Well, I'll, based on those stipulations and agreements, I'll accept the time served plus 10,000.
I'll accept it as well.
And I'm just going to hand up the 10,000 to Secretary's office.
Yeah, I'll take that.
Yes.
Enforcement? It would be enforcement. Enforcement. Yeah, if we're done, I can just go right over there.
Well, hold on.
1 second.
We got to adjourn the meeting.
I have no other items, thankfully.
Chairman, are we adjourned?
We're adjourned, yes.